Morning, everyone. Glad to see so many of you here. Hi, Angel Baby. Yes, to everybody who likes hugs, yeah, group hug to all of those. For those of you who don't like that, then, you know, fist bump or positive vibes. Yesterday was tough. Good morning, Ellie, Nikki, Peter, Roz, reporting for duty. Hi, Finland. So somebody's saying thanking me for the stream and the care, and I've noticed, and I was really happy to see this. I noticed how you care for each other, and that's really great. This stuff is so hard to watch. I think that seeing so many people in the community, good people, compassionate people, even though you're all different, everybody comes from a different place, sees through a different lens, and maybe you don't always agree on one issue or another. You're all still human, and everybody is showing everybody else some empathy, some tolerance, some compassion, and it restores your faith, right? We show each other that, hey, even though we're watching evil, there still is a lot of good in the world. Good morning, South Africa. Good morning, Scotland. A little compassion goes a long way. Yeah, yeah. Sometimes when you're good to somebody, just out there in the world, just a little thing, you don't know what you've done for them. You don't know where they were in their head. They could have been having a horrible day. They could have been thinking dark thoughts. They could feel unseen. And just that human connection, that little act of kindness doesn't have to cost you anything, can really change a person's day. Good morning, Nancy. Nancy's like, yep, to all the huggers, here's a hug, and to everyone else, here's that fist bump. Scully saying, I started the morning by rewatching your video of the interrogation. Oh, and I'm stuck on your words. She torched this man. And she really did. I don't remember saying that. That video was so long ago. I think if I went back and looked at it, knowing what I know now, I would have things to add. Good morning, Deborah. So I'm going to check our stream, see what we got. The Silver Leaf is saying, I would love for the prosecution to use the video of Sarah saying what George's family called her as the final part to closing. I'm not sure if they really called her this, but I know I would have. DM is asking, did the defense know that the prosecution were going to show those videos? Yes, they did. The defense had copies of all of that, so they knew. They also knew, and Sarah was warned too, specifically, that if they wanted to introduce BSS, that those videos would then be fair game. Those videos would come in if she claimed that. So the defense knew that. She knew that. I think, in her view, everything evil that she did should be disregarded, and her narrative and her version should be accepted. Never mind the facts. Her version is the version of reality that you must adopt. So I think that's how she lived. High acquired taste. Al says that you think that the prosecution case is stronger because BSS was allowed to run. Yeah. Good afternoon, UK. Robin says, I feel like it was premeditated murder. I've been saying that for a while, but I also think that it would be a really tough case to prove that. Romeo Saints says, hi, Lori. The Watson's good group name, right? Somebody suggested that instead of calling you guys, that I call you Sherlocks. I thought that was pretty good. Tallulah, I hope I'm pronouncing that correctly, says, I've really enjoyed interacting with everyone today, and I'm hopeful for some resolution today. Thanks for all the support in the chat yesterday. I love that. Leslie says, it's going to be a good day today for George. Much endeavors. The way she spoke to George on those videos is so sad. Yeah. The Silver Leaf. Sorry, was trying to send that as a super chat. Thanks. Thanks. It goes to Watson's stick fund or toy fund. Acquired. Oh, gosh. Okay. Sherlock's to your Watson. That's cute. Yeah, it wasn't my idea, but I thought it was good. DM, he was calling her ma'am when answering her questions. Yeah. Yeah. That man was just beaten down. He was the one trapped in that cycle, right? William, I got a bit too emotional yesterday. My apologies. I was unprepared to see how weakened George was. Yeah. Yeah. And I don't, William, I do, unless you said something crappy to somebody, because I didn't see that. I didn't see you doing that. There's no need to be apologetic for being emotional. You're a human being. I've got my window open. If the background noise bothers you, let me know. Cookies is asking, how do you think the jury instruction debate is going to go? I think it's going to be flippin' ridiculous. You saw Owen's behavior yesterday. He's going to, yeah, it's going to be tough. Crafty Florida lady. I'm in the hospital in Florida. Oh no. And I've been unable to follow this case like I would have liked. They aren't buying her blank, are they? They're not believing her, are they? I don't know. So I was checking social media last night because I wanted to kind of get a beat on what the general public is thinking. And I noticed a lot of people really horrified by those final videos. But, there are some people still, not converted. Let me put it that way. Mary, what I didn't understand was why, when they showed the video of them both getting arrested, they didn't show her getting arrested. I am not entirely sure. I don't know if that was by agreement. I don't know if that was, well, I don't think it was held back. because my understanding is they're reading text messages today. It could be, thank you, Scottish Lass. It could be an issue of arguing because really you're not supposed to show that stuff. She was not convicted of that, but we know she wasn't convicted because she was in control, and so she could convince him to get those charges dropped. And when she went and got charges dropped, it's because she wanted her toy back. She wanted her toy back. And there were other times that the charges were dropped against him, and there's no indication that the reason they were dropped is because she did something or that she requested it. There was one case like that. I went and looked into all of that. There was one case where she requested it. The rest of them, it doesn't say why. And charges get dropped because there's no reasonable prospect of conviction. Now, I can't say that is why the prosecutor did that in those cases or not. I can't say for a fact. I'm not in their heads. But that is a big reason why that happens. So it's not like she was the one who always got him out of trouble. She just used the system and him and everybody else the way she darn well pleased. Hi, Dr. Barry. She definitely objectified him, yes. The videos were clear that she took his humanity, yes. Absolutely dehumanized him. If I saw someone treating a dog like that, I would be furious. He's a human being. KPM, the very last video yesterday was her coaching him on what to tell the court to get her off her felony charge. Yep. Yep. And that is also a crime, by the way. You can't do that. Rita says Owens has given Boone the defense that all her former attorneys refused to provide. They all said no. Yeah. Shivani says, do we think those videos were on her phone or she deleted them and they recovered? Because I don't think she would willingly hand over her phone knowing these videos were on there. They didn't say that they were deleted. I think she might hand over her phone knowing they were on there. And the reason I say that maybe she would is because in her mind, everybody should just listen to her version of reality, just look at the bits that she wants them to look at, and ignore everything else because she said so. And we saw that through her letters. She would make allegations and conveniently ignore other facts and twist things around. She did it to George. I want you to capitulate or change, mold your mind into my version of what I want reality to be. And she's not crazy. Dr. Barry, I think she thinks those videos make him look bad because she lacks insight. Yeah, she does lack insight. That's for sure. And that's the thing with her. I think if she sat down and was really honest with herself, I don't think her ego could handle it. I think this is part of why she delayed trial. She can't handle accepting things about herself. She just can't. She would fall apart. Matcha, someone posted Sarah Boone's divorce letters. Yeah, I did a video on that. The video is called "Is Sarah Boone Damaging Her Defense?" And it was all about that letter. Good morning, Janet, Patty, Mama Bell. Yeah, insisting he call her an angel. Yeah. Oh, and the bit about, and she's the type of person who would stop to pick up an animal on the road, no matter how much traffic there was. All this just extreme, right? Goes along with her extreme language that she used in her letters. Everything is everything is in the extreme, even in her language. Aaron says true narcissists are deeply insecure. They have huge egos, but those egos are very fragile. Yeah. They fear inferiority deeply. Yeah. And I thought for a long time that she could have been borderline because I thought, and I was mistaken, I thought I was seeing some worry of abandonment. But after seeing the videos yesterday, I've changed my mind. Dr. Barry says, I wish we could have seen Brian Boone back on the stand. Yeah. But I'm glad they're keeping him out. I think he was one of her first victims, emotionally and financially. Yeah, I agree. And a lot of people, myself included, have questioned what the child went through and what the child would have gone through had she been allowed to continue to be a major part of his life or to continue to have unsupervised access. Stacy, I wonder if Brian would have ever come out to tell his story after this nightmare is over. He doesn't strike me as the type who really wants to be involved or in the public eye or anything. I'm going to check our stream. Oh, here we go. I am streaming through Trial TV Live, so I want to give a shout out to them. I put a link in the description, so if people want to show them some love or um, just stream with no commentary, there is a link to their channel in this video description. Christopher is if he was able to stay in the child's life, if she was, she would weaponize him as a man to do her violent bidding if they got that far. The tireless Mr. J should be proud. His office and some kind officers unfolded a humane story. Yeah, yes. I was impressed with the officers that we saw on the body cam. They were asking good questions. I mean, they're supposed to, right? But even after that very hot, intense moment where they're going into a home where things could go sideways really quick and they know it. So they know that's a dangerous situation, both for the member of the public and for the officer. Their adrenaline would be through the roof, and they were able to deal with that. I mean, some part of training is stress inoculation, we call it, but that's tough. And they did. They showed him compassion. They were patient. They gave him space to think and speak if he wanted. I thought they were really good. Patty says Sarah had a girlfriend in jail. Yeah, I don't care. CB, when George said, if I called, would you have come? Yeah, that killed me. That really got me. Good morning, Boole. Or it's Boo ICU. Oh, I get it. Sometimes it takes me a while. Oh, it looks like somebody said Owens and Henderson are furiously going through paperwork. Yeah, they got a lot of work in front of them today. Somebody said, I think the cops knew that George was the abused one. Yeah, you can tell. When I was watching those body cam videos the first time, I just thought, oh, come on, Sarah. It's so obvious. She couldn't. They ask her what happened. And she's like there's this big silence. Excuse me, just wait a minute, officer, while I come up with my lie. And even the language that she used in telling the story just screamed out lie, 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 lie. And top of the morning. I had a chief who used to come in every morning, top of the morning to you, Lori, and he had this accent. So I just loved it. That was my reward for being in early, just to hear him say that to me. Dr. Barry, they were aggressive with him at times, trying to get him to talk, but they seemed angry with him, in my opinion. Yeah, yeah, you know what? I can see that, and I can see somebody who is vulnerable feeling like really feeling that even more than what we might watching. They just, 1 second before had their adrenaline is through the roof because 1 second before that they think there's a possibility they could get killed. DVs are the most dangerous situations for a police officer to be in. Thanks, Jackie. Um, DVs and traffic stops are terrifying. They'd rather go to a bank robbery where they know there's a weapon. So it's not only as dangerous for the officer, it's dangerous for the person who the police were called on. So that was dangerous for George. So, and I'm not saying that that they didn't sound angry or short or impatient. I'm not saying that. I think maybe just because I can relate. It's really hard when your whole physical system is like right up here to just suddenly calm down and modulate your tone really well. Rita says the state is sitting quietly prepared for what is to come. I don't know that the defense is unprepared. I was laughing at Owens yesterday because he was saying, we're ambushed. And then he opens his folder and he's got pages and pages that are tabbed and organized that were for the very purpose of the thing he was ambushed for. So he wasn't ambushed. He knew. Oh my gosh. So someone in the chat just said my husband was approaching a car, and as he got close, he saw all the occupants in the car raise their guns. Yeah. You really, you don't know what you're walking into. Leslie's saying she thinks Sarah documented every bruise she got to add to her collection, and perhaps whether she got those bruises from George or not. That's a possibility. I've seen it. And this is the thing that gets me so mad because there are so many victims out there who aren't believed, who are looked upon with doubt. And sometimes the abuser will say, nobody's going to believe you. Oh, I'll just tell them this. They're going to think you're crazy. So they're afraid to report. And any indication from a listener that they're not believed can cause the victim to just shut down. So there are a lot of people suffering out there who never ever get heard for a variety of reasons. And one of them is somebody like Sarah.
Madam Clerk, I'm ready.
Case number 2020 CF603, the State Board versus Sarah Boone, appearances of record state.
Dave Ketchcore on behalf of the state.
William J. for the state.
Defense.
James Owens for Sarah Boone.
Tony Henderson for Sarah Boone.
Kevin Beck on behalf of Sarah Boone.
Ms. Boone, raise your right hand to be sworn, please. Do you swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Ma'am, good morning. Can you please state your full name and date of birth for the record for me?
Sarah Boone, 10-10-77.
All right, Ms. Boone is seated at counsel's table wearing a light gray suit and a white blouse. She is in custody, however, will not be wearing any restraints. As such, we will continue to stand when our jury enters and exits. We're here for a charging conference. The court has reviewed, I believe, both parties' red lines as to the jury instructions, including, I believe, that was submitted last night, the defense's red line as to the...
Again this morning, her cadence, her volume, and her whole demeanor exudes confidence. I don't know that. I'm suspecting that she thinks that what we all saw yesterday is fine, that she can still get out of all this. Interesting. And just fair warning for those of you watching, some of this might seem boring. So for those of you who know what's going on, please feel free to explain it to other people in chat. I might miss questions. I might not know everything. My experience in law is here, so there could be rules in Florida that I'm not aware of. So let's go.
The jury instructions that were provided by the court. Let's try to get as much done as we can until our jury arrives. I believe what we had discussed yesterday was starting at the beginning and moving through as quickly as possible until we get to the real meat of some of the issues in the 3.6F and the 3.6G instructions. Mr. J?
May I remain seated during the charge conference?
Yes, sir, you may. Thank you. All right. I have in my hand a 34-page document that was emailed to the court last night by counsel for the defense at 12:06 a.m. from Lauren Henderson. That's what the court's going to be relying on. Does everyone have that in front of them?
Yes, sir.
Defense.
Judge says he gets up at 5:30 a.m. and he got an email at 12:15 in the morning. Owens is notorious for this. Mr. J, I hope he gets to take a nap for a week.
Defense.
Basis, yes, Judge, I did.
Okay. All right. Let's start on page 1 of 34. 3.1, Introduction to Final Instructions. Any objection to the form of this instruction? State.
Now I'm confused. I don't know that I have a 34-page document from them last night. There was an attachment. There was an email at 12:06.
Hang on. Let me make sure.
Attachments. 36F, separate red lines. 36G, separate red lines. 8.9, culpable negligence, red line separates.
Give me a moment. Then it was what was sent at 11:31 yesterday.
That 34-page document I have.
Okay.
Well, 31. I don't know if it's 34. It says 31 to me.
So again, the state doesn't have what they're supposed to have because the defense didn't send it? Is that what happened here?
I have it as 34. Okay.
Excuse me, Judge.
Yes, sir.
Can I have Ms. Henderson explain how she sent the document?
Fine by me.
Your Honor, yesterday morning, 11:30, I sent the red line instructions from the defense based off the document you had sent to us yesterday morning. And then last night, we approached and I had asked if that format was okay for you. And I believe Mr. J had said, could the defense send separate 3.6, 3.F, so it'd be easy to incorporate in your final instructions.
And that's what was sent at 12:05 last night. All right.
Just for more convenience for you.
Understood. Okay.
Thank you.
But the balance of the instructions, because that just addresses those.
I'm sorry, what was that?
What you just advised only speaks to the 3.6, 3.6G instructions.
And F and culpable negligence.
Correct.
Yes, sir.
Okay. All right. So I'm talking about the balance of the instructions that may or may not be at issue.
Yes, sir. That was the balance of instructions that are not at issue. Those are what was sent at 11:30.
Okay. All right.
My confusion is the court is indicating they have a 34-page document.
Yes, sir.
I have a 31-page document that was emailed to us by Ms. Henderson at 11:32 in the morning.
Are you looking at October 24 at 11:31 a.m.? Subject, defense proposed jury instructions in red line format?
I'm sorry, Mr.
No worries. I'm looking at the email correspondence of October 24, 2024, 11:31 a.m. Subject, defense proposed jury instructions in red line format. Is it possible that you don't have your track changes are off, and maybe that's why? That's the difference.
Where the track changes, please?
In Word, under review, or I can just have Madam Clerk print out 2 more copies. And we could just work our way through that.
Sometimes it's as simple as, the margins are different, formatted differently,
Everyone is still only 31.
but they have to make sure.
Okay. I just forwarded to Madam Clerk. I'm gonna have her print out 2 copies. That way we've got hard copies, so we seem to be all on the same page.
Criminal Minds has coffee fudge ice cream to sit through this. Yeah, I love this judge. Nala says, glad they are comparing. Yeah, they have to, though. Elle's saying, I'm supposed to be cleaning the house, but I'm watching this. Yeah. I used to give my kid heck for leaving dishes in his room. You should see my desk right now. Colette's saying, knowing how Owens operates, the prosecution is probably really suspicious if there's a page missing. Yeah, definitely. And you get to know the counsel you're working with. Sometimes prosecution and defense will agree, or one side or the other will say, yeah, okay, whatever he says is fine, because they know that both of them are not playing games like that. CB says, been waiting years for a guilty verdict. Yeah. You guys are talking about ice cream and donuts, making me hungry. Good morning, Manitoba. Cookies is saying, I could never be a judge or a lawyer. Too much patience is required. Yeah, you do require a lot of patience. But then there's the time when you go out back for a smoke, or everybody goes to the same hangout, and either at lunch or after hours, and just kind of rant about various things. Oh, so Crafty Florida lady is asking why I think Sarah turned down the plea deal. I have thought for a long time that she can't handle being called a murderer or being seen as a murderer. In order to take the plea deal, she would have had to admit that she did this. She would be guilty, and I think she can't handle being guilty. I think she thought she could win because, let me impose my reality on you, and then everything will be fine as long as you get in line with my reality. I did a video on that too. Beware of what the imposed fantasy. That's the title of the video. I see that in her. Anna, she's going to have to handle it now. Yeah. Good morning, Anne. Somebody said she wanted to win in front of, I'm not sure, in front of the world, though. Yeah. And she addresses the world and the public in her letters. Somebody said she'll never admit her guilt. I think even if she's convicted, she won't. She is not going to engage in any reflection. Not self-reflection, anyway. Vel asks, why didn't the state question her more thoroughly? He seemed easy. I think one is because he could have gotten the weeds and questioned forever. Also, it could have looked like the big mean prosecutor bullying this poor victim. It could have looked like that. And Sarah's own actions speak for themselves. It will be Sarah's own words and behavior that convict her if the jury convicts. Somebody said, yeah, she's incapable of self-reflection.
All right, both parties have what was provided to the court yesterday, a 34-page document, which includes the defense's red line with regard to the proposed jury instructions. We'll start on page 1 of 34. Instruction 3.1, Introduction to Final Instructions. Any objection to the form of this instruction state?
No, Your Honor.
Defense?
No, Your Honor.
Moving to page 2 of 34, Instruction 3.2, Statement of the Charge. 8.
No objection.
Defense?
No objection.
Moving to page 3 of 34, 7.1, Introduction to Homicide. Those 3 paragraphs, any objection?
No objection from the state.
No objection.
Moving to the next portion, justifiable homicide in the singular paragraph. Any objection, state?
No objection.
Defense?
No objection.
Moving to excusable homicide and the 4 paragraphs, including paragraphs numbered 1, 2, and 3. State?
No objection. I have no objection to anything I submitted to the court.
Okay, thank you. Defense?
No objection.
Moving to page 434, 7.4, second-degree murder instruction. Defense, any objection to the form of the instruction?
No objection.
And also the removal of the lesser included chart on page 5 of 34, correct?
Correct.
Moving to page 6 of 34, instruction 3.4, when there are lesser included crimes or attempts. My only question is, if I understand from the defense, they're looking to see culpable negligence is a lesser included.
Yes, Your Honor.
Would that not need to be included here?
Yes, Your Honor.
Okay, so is the only addition to this the balance of the 3.4 instruction would be correct with the exception of the last sentence, which would read the lesser crimes, plural, indicated in the definition of second-degree murder is manslaughter and followed by culpable negligence.
Yes, so it should go to R. Yes.
State?
State objects. There's no evidence to support a misdemeanor culpable negligence lesser included offense for a category 2 lesser to be included in the jury instructions. They both must be supported by the charging instrument as well as the evidence in the case. There is no evidence in this case that he only suffered culpable negligence. The crime for culpable negligence with death is manslaughter. Culpable negligence isn't even a category 1 lesser of manslaughter. It's a category 2 lesser, which includes, by inference, there must be some evidence that her culpable negligence did not result in death.
Defense is trying everything they can, right? So, I mean, they're even going as far as wanting to be able to include a misdemeanor. Come on.
What's your response to that?
Judge, the instruction that we're asking for is 8.9. It reads to prove the crime of culpable negligence. The state must prove the following 2 elements beyond a reasonable doubt. 1, Sarah Boone exposed George Torres Jr. to personal injury. And 2, she did so through culpable negligence. As to the fact that there is evidence of culpable negligence as to the case, and the fact that Ms. Boone, while Mr. Torres is still in the suitcase, goes upstairs. As to it being charged, it's a category 2 lesser included that's available to the defense. Defense can get category 2 lesser included offenses as long as there's evidence to support the category 2, and there is evidence in this case to support the category 2 lesser included.
Mr. Henderson knows the law. And that was apparent early on, even when they were arguing about whether or not to get in BSS. So, and he is very cleverly sort of parsing this out here, forgetting about the part that she didn't just expose him to danger, she put him in the position of the danger. This is not like, you knew your porch was broken and you didn't, put up a barrier or a warning sign. Like, come on.
And any other further argument, Mr. J?
No, Your Honor.
Okay, all right. At this point in time, the court is inclined to include the culpable negligence as a lesser included. We'll get to the instruction momentarily. Any other revisions to the 3.4 instruction, defense?
No, Your Honor.
Moving now to 7.7 manslaughter, there are some objections. The defense is now objecting to paragraph 2C, the death of George Torres was caused by the culpable negligence of Sarah Boone. So how could you ask for a culpable negligence instruction and then object to 2C in the manslaughter instruction? I'm logically having trouble understanding that.
This is my argument, because I'm not arguing that there isn't evidence of it, because I just said there's evidence of culpable negligence. The difference is, and I think the burden is different from the state, because it's not alleged in their information.
Does not the instruction say give 2A, 2B, and or 2C depending upon allegations and proof?
Yes, the allegations would be the information.
Okay. Any response, Mr. J?
Judge, it's a category 1 lesser. All the theories are included in that. The language does not need to be included in the charging instrument. And quite frankly, it's not inconsistent with the language in the charging instrument. She's accused of having a depraved mind when killing him, and what the evidence has also shown is that she was heavily intoxicated when she made this decision. That supports a conclusion for a trier of fact to reach that this was out of culpable negligence, and if they reject our argument that it was done knowingly and out of hatred, ill will, spite, etc.
Any other argument, sir?
No other argument.
At this point in time, the court is going to overrule the defense's objection as to the objection to 2C in the manslaughter instruction, including the final 2 paragraphs of what the definition of culpable negligence is on the bottom of page 7 of 34. It seems like it's stipulated between the parties that 2B, Sarah Boone intentionally procured an act that caused the death of George Boone, should be George Torres, is not applicable. Is that correct, State? Is that correct, defense? Okay, thank you. And also, since 2B is not applicable, the to procure definition will not be provided. Any other questions regarding the 7.7 instruction?
So for those who missed it, Henderson didn't get that. It's not really that big of a deal, though. I mean, it would have been a big deal if he got it. It would have been surprising, but he didn't.
No, sir.
No, Your Honor.
No objection to what they suggest is the definition of culpable negligence as the court's going to use.
With regard to the
Second lesser?
second lesser? Yeah, thank you.
No objection to that proposed instruction.
All right, very good. Thank you very much. What is the instruction number for the culpable negligence instruction? I think it's 8.9, isn't it?
8.9.
Okay, thank you very much. Moving now to page 10 of 34, 3.6D, voluntary intoxication. Does this now need to address culpable negligence? Or is that only...
No, yeah, we would request to add it, the culpable negligence, since it's going to be given. So it should read second-degree murder, comma, manslaughter, comma, or culpable negligence.
You're talking in the last sentence, correct? Voluntary intoxication is not a defense to second-degree murder, manslaughter, or culpable negligence.
Yes,
correct?
Your Honor.
Thank you. Any objection,
No,
defense?
I agree.
Thank you.
Defense can't really object to that because that's.
Do we want to take an attempt to address the 3.6F?
I would suggest we do that later and see if we can just get not
This-
3.6 done.
At this time, we're just going to make a note that we're going to bypass the 3.6F instruction and 3.6G instruction. That'll take us all the way to page 23 of 34. Instruction 3.7, plea of not guilty, reasonable doubt, and burden of proof. Any objection to the form of this instruction, defense?
No objection.
Moving now to page 24 of 34. Weighing the evidence, 3.9 instruction.
Should we go to 3.7, plead not guilty?
Did I skip it?
Yes, sir. Page 23 of 34.
I'm sorry, I thought that's what we just covered, Mr. J. I apologize.
I was just making sure that there were no edits that either weren't made or the defense made, so I was scrolling, but no objection to 3.7.
Okay, thank you. Moving now to page 24 of 34, 3.9, weighing the evidence. Looks like give as applicable paragraphs 6, 7, 9, and 10 have been struck. Is that acceptable? State.
Yes, Your Honor, I agree that 8, the inconsistent statement instruction, should get bumped up to 6.
Agreed.
And the remainder should not be read.
With those revisions, is that instruction 3.9 acceptable to the defense?
Yes, Your Honor.
Okay. Moving now to page 25 of 34, the latter portion of the 3.9 instruction. Any objection to the language contained on this page? State.
No, sir.
Defense?
No, Your Honor.
Moving now, the 3.9A instruction was struck by virtue of Ms. Boone testifying in this matter, so that need not be addressed.
So some people in the chat are saying what is actually going on. So right now what they're doing is working out what the instructions to the jury will be. And there are some form instructions that won't make sense given the facts of this case. So they need to work that out as well. And everybody has to agree. And if they don't agree, then the judge has to make a decision. And the wording, as many of you know, the wording of these jury instructions is really important. It has to be understandable to the jury. Often those instructions can be really complicated for a juror who has never had to deal with the law. And so they're just kind of going back and forth. There are some things that they can't get away with doing, some things that they must do. They have to rely on the law. And so, you know, both sides might sort of split hairs and argue about language and why this should be in or why it shouldn't be in, because these jury instructions are going to have a great deal of impact on how the jury examines the evidence and how they come to their decisions and what options they have if they choose to find her guilty of something. They can't just say, you know, she's charged with second degree. We think it's first, so we're gonna do that. They can't do that. So it all has to be laid out. So hopefully that made sense. And I know they're talking, you know, about this page and this number, and we can't see the pages and the numbers. When it becomes important, you will hear, because you will hear them discussing it back and forth. Hope that made sense to everybody.
The 3.9B defendant's statement instruction also included the requested language by the state. Is there any objection to the form of this instruction at this time? Defense?
No, Your Honor.
Okay, Ms. Boone, earlier this week, and I can't recall if it was yesterday or the day before, the state had filed a motion seeking to add additional language to this instruction. And I had read that language to you at that time. Do you want me to read it again to you this morning?
Yes, please.
Okay, so I'm going to read you the entire 3.9B instruction. 3.9B defendant's statements reads, a statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including, but not limited to, 1, whether, when the defendant made the statement, she had been threatened in order to get her to make it, and 2, whether anyone had promised her anything in order to get him to make it. That should be revised to the feminine. Any objection?
No, Your Honor.
Defense?
No, Your Honor.
That is the form instruction created by the Florida Supreme Court, ma'am. What has been added is the next paragraph, which reads, law enforcement is not legally required to ask a suspect whether he or she wants to talk to law enforcement after Miranda warnings are read to a suspect. This is, however, one of the factors you may consider whether the defendant's statements were voluntarily made. Similar to other conversations we've had this past week, ma'am, I don't want to know about specifics of any conversations that you had with you and your attorneys, just simply whether or not those conversations have been had. Did you and your lawyers discuss the proposed language that I just read to you?
Yes.
Do you have any questions with regard to that proposed language?
No.
Are you in agreement with this additional language being added to this defense?
Yes.
All right, thank you. Or to this instruction, rather. Thank you.
So all her ranting in her letters, ooh, the detective was wearing a gun, and all her, citing case law. She didn't even cite it. She just kind of like repeated it. She just vomited it on a piece of paper. All that, all of Owen's arguments about Miranda, all that comes down to this. And she has no choice but to sit here and say, yeah, I understand. Yeah, I agree. There's be no more wiggling around about that issue for her. She's done on that, and I'm here for it.
The last sentence read, if you conclude the defendant's out-of-court statement, was not freely and voluntarily made, you should disregard it. Any other clarifications to that instruction statement?
No, Your Honor, thank you.
Defense?
Judge, in looking at it, it says in the final part, consider whether the defendant's statements, can we replace and put rather Sarah Boone's statements?
Where are we specifically, sir?
In the state special that I have no objection to, it says, this is, however, one of the factors you may consider whether the defendant's statements, if we could have Sarah Boone's statements, were voluntarily made.
The language used all throughout the instruction is the defendant.
Yeah, I tend to agree with the state on that.
Okay.
Rule 3.10, or I'm sorry, instruction 3.10, rules for deliberation, page 28 of 34. Looks like the parties agree that paragraph 7 is not applicable.
Yes, sir.
I agree.
That would change paragraph 8 to 7. Any other revisions to 3.10?
Not this.
Defense?
None from the defense.
Moving to 3.11, cautionary instruction. Defense?
No objection.
The court then interlineated on page 30 the 2.7 closing argument form instruction. Any objection to that instruction, state?
No, Your Honor.
Defense?
No, Your Honor.
Moving now to 3.12 verdict instruction, page 31 of 34, state?
No objection.
Defense?
No objection.
Moving now to 32 of 34, instruction 3.13, submitting case to jury. The only other question I have for the parties is with regard to, I believe it was Exhibit A, the suitcase. Are we going to send that back, or is that going to be viewable upon writing similar to the baseball bat?
No reason that it can't be sent back.
Okay, agreed?
Agree.
Okay, all right. Is this instruction acceptable to the state?
Yes, Your Honor.
Defense?
Yes, Your Honor.
Very good. And then moving to, that concludes the, except for the 3.6F and 3.6G instruction, that includes the verdict or the instructions. I'll have Anita clean that up and send it to the parties so that we...
Somebody's asking if closing is next. The answer is no. So they're working on these jury instructions this morning. The jury is coming in again at supposedly 9, and the state is going to continue its rebuttal case. So that's what's happening.
We have a cleaner red line to work with. The only other question that I think we can address this morning is the verdict form. I received the defense's verdict form, and it looks like manslaughter is no longer being sought in the verdict form. Manslaughter was struck out and it was just culpable negligence.
Under the offense's part, yes.
Right.
Yes,
Okay.
Your Honor.
So how do we want to address the verdict form then? Because if we're giving instructions on manslaughter, certainly needs to be included in the verdict form.
I understand, Judge, but the defense isn't requesting manslaughter, but if it's instructed, it has to be in the verdict.
So the verdict form would read, we, the jury, find the defendant guilty of murder in the second degree as charged in the information. We, the jury, find the defendant guilty of the lesser included offense of manslaughter. We, the jury, find the defendant guilty of the lesser included offense of culpable negligence. We, the jury, find the defendant not guilty. Is that acceptable to the state?
Yes, Your Honor.
Is that acceptable to the defense?
Yes, Your
All right. Similarly, I'll have Ms. Barrios make those revisions and submit them to the parties as soon as possible. Anything else, state, we need to address before? Bruce, do we have everybody as of this time? Everybody's here? Thank you, sir. Other than the 3.6 instructions and the state's request for other instructions, which I think we'll have to table for now,
Yes, sir.
are we prepared to go ahead and bring in our jury at this time?
Only thing I wanted to bring to the court in the defendant's attention was apparently yesterday at lunch there was some sort of domestic violence event out in the quad. A coworker indicated that without believing it was any particular jurors in this case, that he did see people with juror badges in and about the area. So I don't know if that warrants inquiry by anybody.
Defense?
I think it should be mentioned.
I agree.
Okay.
I agree.
Just to see,
Sure.
we spent all this time, we've got a bunch of alternates. Let's utilize them, but I do.
Oh boy. Okay. Did y'all catch that? I was thinking yesterday, it's so far through this trial, there have been no juror antics, and that's great. And now there might be something, not the fault of any jurors, but I guess somebody set up like a domestic violence, bench or display outside the courtroom, and jurors were seen in the area. So they are going to have to ask about that.
Yes. What do we got?
I think the state attorney, the last piece of evidence is they extracted from Sarah Boone's phone a bunch of pages of text messages. And I believe their intent is to introduce all those text messages, which were quite a few, but I think they want to read specifically out a few to the jury. My only concern is I don't know which ones they're going to read out, and under the rule of completeness, if there's a thread where it needs to be put in context, we would ask that all of that be read. So I don't know exactly what they're planning.
Mr. J, any response?
It's going back with them, just like I told them during some of the body-worn cameras. Only some of it's published. It's all going to be there for them to use. I do not intend on reading all 108 pages. I don't intend on trying to delineate what contextually is one conversation from the other. I think it's just fair to say this is all going back with you. You're going to have a scrub laptop. You're going to review it all.
Okay. Mr. Owens, you can make any objections you deem necessary at the time, and we'll address it. Because it's just hard for me to say what should or should not be. I understand the state's position, but if it's something that's
Owens is like, read 1,000,000 pages, including all the stuff that doesn't actually matter, because just bury everybody, because that's how I am. I know. Okay, I'm joking. There is a rule of completeness. He is technically correct, but the whole text stream is going back with the jury, so that rule of completeness is satisfied.
you believe in the rule of completeness should be provided at that time, regardless of it going back, we'll address it.
It's going to be about 40 minutes worth of reading text messages. Are we going to have some people come in to read the messages?
Again, I'm not sure how long it's going to take. I did not practice reading what I'm going to be reading in the mirror. Number two, no, I don't understand why a witness would be called. It's in evidence. The lawyers can now publish them.
Anything further, Mr. Owens? Okay, all right.
P.T. Barnum wants to know if the prosecution's hired, witnesses or brought in witnesses or going to hire actors to like act out these texts. He's the way he thinks is a little bit, I know people like this, it's a little bit bizarre.
Not on that issue, I would like to take like 5 minutes to use the bathroom.
Sure, we can do that. Okay, so I don't want to highlight that it was a domestic violence event. So are the parties, is it acceptable to the parties to inquire of if anyone heard or participated, got any information, or observed anything of the event that transpired yesterday afternoon in the courtyard? Is that acceptable?
Yeah, you definitely shouldn't suggest what it was.
Agreed. Okay, got a thumbs up from Mr. Owens. All right, we'll take a 10-minute recess. We'll just plan on bringing back here at 9:30. We'll bring the jury in at that time. Thank you all very much.
Okay, I'm going to fast forward. See, it's okay when we get behind because then we don't have to sit through breaks. Okay, so they are still on a break and we should be back soon with the jury. Martha says Owens is constructing the tricks. I notice he has more of his placards. He likes the big blown up thing. It's interesting to me because nowadays they just use the computer and put it up on the screen. He could have done that. So it makes me laugh. It's a little bit old school to me. I know a lawyer who never even got a fax machine. I mean, that's how far back he goes. So he would have his correspondence walked over to the courthouse by courier because he didn't even get a fax machine. And then when fax machines became obsolete, he told everybody, see, I saved all that money on a fax machine. It was hilarious. Good morning, Susie. Heart Machine is asking about the courtyard. Yeah, there was a display or something about DV in the courtyard outside of the courthouse. And the court wants to make sure that the jurors aren't going and getting extraneous information to read up on the subject, because that's the subject in this trial, right? So they're going to have to inquire. A pretend judge is saying, can you explain what just happened in court? So what just happened was that they had to work out what the jury instructions were going to be. So that language is important. The law and how it applies is important. So that's what they were doing. They were just going back and forth, working on that. Sounds to me like they have more work to do on that, but the state has not finished their case and the jury is waiting, so they're going to get court going. Dominique says it's DV month, yeah. Shmita is saying it was just a few people outside the court with flags and a megaphone? Really? They referred to a bench or like some sort of a display. Good afternoon, Ireland. So Tiffany's asking what would happen if the jurors did get or see some information from the DV setup outside of the courtroom. What would happen is the judge would have to question that juror and see if it had any impact. to find out, okay, what was it you saw? What did you read? That sort of thing. And they would take it from there. BJM says, I'm seeing how little DV info includes men. Yeah. Hopefully that's changing. Oh, somebody's asking about Sarah's defense and thinking that she was supposed to use either BSS or accident, and she sort of weaved in both. I fully expected that. And the question is, well, why didn't the state object? How can she do that? And she can. When they discussed the case law about that, the when you look at case law, there's such a thing as distinguishing cases. So if you look at case law, it sets out these principles and this set of facts. If you want to use the principles in that case law, you take the case law, you cite it to the judge, and you say, Judge, this is how these principles apply. The facts of my case are very similar or exactly the same, whatever. And another lawyer might say, the principles apply, but they don't in this case because the facts of my case are slightly different, right? So in the case law that they cited, the accused had a firearm that went off accidentally, right? So that's a, split second. It went off accidentally. Well, logic dictates that she can't then say, oh, I had to do it in self-defense. Was it an accident or did you do it in self-defense? Sarah's case is different. It's not like she accidentally zipped him in the suitcase, right? It's not like something happened in the spur of a moment, right? She put her foot on the accelerator instead of the brakes or something, or a gun went off. So the facts are different. So you have to take that into account. So logic has to play into it, right? So she can say, yes, I struck him in self-defense, and in striking him, I just intended to stop him. I didn't intend to cause his demise. It still doesn't fly because she still walked away. Like, still none of it makes sense. And I suspect that Mr. J, remember when they did the demonstration in the courtroom where Sarah, with no emotion and no problem, I mean, almost eagerly, was messing with that suitcase, right? I mean, would you do that? Wouldn't you be horrified to see the instrument of your loved one's demise and touch it?
Seated. Thank you.
Mr. J had her zip it and show the jury, okay, this is how it was zipped. This is how much space I left. And he asked her specifically, did you change that from the time, because we're talking about the 11 minutes between the two videos of the suitcase, right? Did you change that zipper after that? And she said no. And I suspect that in closing, Mr. J is going to show the second video of the suitcase where you can clearly see that zipper is shut. And he's got that suitcase in the box there, zipped up by Sarah Boone herself, showing how the zipper was open. And he's going to show the video, and he's going to take out that suitcase and let them see for themselves. That's what I think is going to happen. Anyway, they're back, so we'll keep going.
All right, we're back on the record, case number 2020 CF 2603, State of Florida versus Sarah Boone. Let me get appearances for counsel, starting with counsel for the state.
Steve Castro on behalf of the state.
William J. for the state.
James Owens for Sarah Boone.
Tony Henderson for Sarah Boone.
Ms. Boone is still seated at counsel's table. Are we ready to go ahead and bring in our jury at this time? State.
Yes, sir.
Defense.
Yes, sir.
All right, let's stand and bring in our jury.
I'm going to listen to Owen's closing just to laugh at him or yell at him. Suitcase is still in the courtroom because it's evidence. Somebody asked about that. I'm watching the chat. You guys are hilarious.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
Yes.
All right, members of the jury, you can be seated. Members of the jury, good morning. Welcome back to 12 Alpha of the Orange County Courthouse. Just again, if you could raise those hands, confirm you complied with the court's instructions. All right, all hands have been raised. Thank you very much. Members of the jury, before the state continues with their evidence presentation today, I just have a couple of questions to go over with you. Yesterday, there was an event in the courtyard of the Orange County Courthouse. Did anyone happen to observe that event? If you did, please raise your hands at this time.
What do you mean by observed?
We'll get to it. Okay. Did anyone happen to hear anything during that event? All right, and record reflects no hands have been raised. Did anyone see anything during that event? All right, juror number 2, first row. Thank you, ma'am. Did anyone participate in that event? Record reflect no hands have been raised. Did anyone receive any writings or review any material from that event? Record reflect no one has raised their hands. Can the parties approach for a moment?
Good. My goodness. That avoids some grief and some time. Good for those jurors. Aaron, the event was an event related to DV.
All right. Members of the jury, I'm going to send everyone out except for juror number 2 in the first row. We've got a couple follow-up questions for you individually, ma'am. Same instruction I've given you all previously. Please don't conduct any independent investigation or research as to the person, places, things, or charge involved, and don't have any discussions amongst yourselves or anyone else, and we'll bring you back in as promptly as possible. Thank you. You all may be seated. Thank you. Juror in seat 2 on the first row from right to left. You had advised, based on the court's question, that you had observed something. You said, what does observed means? And instead of getting that out in front of every other juror, we just want to have that individual conversation with you now. So tell me what it is that you saw or heard or anything yesterday in the courtyard yesterday.
When we were walking back from lunch, and we saw that they were gathered, and I asked the deputy if they knew what was going on, and he said it was the
somebody Bain talking about domestic violence.
Okay. And you said we were walking. Who's we?
Another juror. I don't want to say her name.
Okay. All right. Is that a juror that was on our panel here?
Yes.
Okay. All right. Do you recall where they may have been seated?
No, in the back over there.
Okay. Do you recall what color her hair was?
Yes.
What,
Would you like me to tell you?
please.
Dark brown or black?
Is it the shorter juror? Okay. Thank you very much. State, any further questions?
Uh-oh. That juror didn't raise her hand to say she saw something, so they may have to question her too.
And after you were told what was going on, then what happened?
I walked back in.
All right. Did you hear any of the speakers?
I couldn't hear anything. No.
Anything further from the defense?
Ma'am, did that affect your ability to be fair and impartial? Thank you.
Can the parties approach for a moment?
So somebody said, oh, tattletale. No, it's important. It is really important. You don't want something to come out later and then for there to be an issue, right? Let's get it all out on the table, make sure everything is good. It sounds like it's going to be fine. And then they can move on without worrying about it.
We appreciate you, ma'am. Thank you so much. We're going to go ahead and bring in the balance of the panel. You can just hang out where you're at, okay?
No, she's not gone. I don't think. It's not enough.
We stand for you. You do not need to stand. We stand for you.
Jury entering.
State, you recognize our jury.
Yes, Your Honor.
Defense, do you recognize our jury?
Yes.
All right, y'all can be seated. Thank you. Again, members of the jury, if I could see those hands, you complied with the instructions during that really short break. Record reflect all hands have been raised. Thank you very much. Mr. J, you may proceed, sir.
Permission to publish from States 21, which was previously marked as P for identification.
You may proceed, sir.
Again, this is a DVD exhibit with two folders in the main directory. One entry is in a folder called Attachments. Another is a PDF labeled Extraction. And for the record, it is 108 pages, and the entire document will go back to the jury, and there will be a laptop provided to them to utilize this exhibit. For purposes of publication, I'm going to go by page number and date unless something requires more specificity. And for to and from, I'm going to just use the name, the contact if one exists, or the phone number if one doesn't. On page 1, creation time for notes, 7:49, asking Jorge or George not to be despicable to me, making more drink after he guzzled his and I shared mine. On page 2, date March 8th, 2018. You are now in a relationship with Jorge or George on Facebook. Metadata entry 100014, etc. for Jorge Torres to Sarah Boone, owner.
People are saying you can't see. Don't worry. He's going to read the stuff into the record or he's going to read the text. So don't worry about that.
Page 3, May 21st, 2019, from 407-716-8684 to Melissa. And he can still live here, correct? Or until I decide to finally get him out if he doesn't clean up his act after tomorrow. On page 9, May 30th, 2019, from a contact labeled as Mom, Jorge or George, to 407-716-8684, which I will just refer to as owner in future references. Where is my clippers in the gray box? From owner to Mom, Jorge, all capitals, dumpster, separate message, like you, separate message, so is your 2 shirts, separate message, no more Rick and Morty, a response from contact Mom, Jorge, to owner, okay. From owner to Mom, Jorge, Lucas cried when he saw the adventure fund was gone, thank you, no wonder you're out, fuck off. From owner, he's the one that broke it because you took it. From owner, wanted to go on an adventure. On to page 10. From owner, be proud, feel good. You made my, quote unquote, our son cry. Cheese stick, Lucas, your kids, get the fuck out of my life and my son's. No one, spinster, good, for, nothing, dumpster diver, that's what you are, and the rest of you. Later on this same page, owner to Mom Jorge, get, all of you, mean, selfish, fuck all you, your firstborn is a joke.
You know, if they didn't call her a blue-eyed white devil or a dragon or whatever the heck that was, they should have. Wow, this is how she's treating Mr. Torres's mom. Now, I don't know if you saw video of her. She's just this sweet senior lady, really nice, truthful. And this is how she's treating them. And the jury didn't hear about how Sarah knocked over Mr. Torres's elderly father.
Going on to page 11, same date of May 30th, 2019. From owner to Mom Jorge, get the fuck out of my life. Lucas 2, bad influence. From Jorge to owner, I am, as you can see, go drink your life away. From owner to Mom Jorge, your kids are too. Yuck. Shucks, I only have one. Beaters, your 3 together. Yuck. Going on to page 12. From owner to Mom Jorge, still dated 5/30/2019. Gross, and all the time, gross. Mom Jorge to owner, I love that guy. I love that guy. You're the one who kicked me out. Owner to Jorge, Mom, finally, get your shot together and check me out in 2 to 3 months. Hope you're there. Unless I find someone better. Shit. Together. From Mom.
So if I'm understanding this correctly, so it sounds like George is using his mom's phone, okay? And it sounds like George is saying, look, get your crap together and then talk to me, basically. So he's not chasing after her. She was the one chasing after him and haranguing him. I mean, he couldn't get away from her.
Mom Jorge to owner, are you serious? Are you serious? Owner to Mom Jorge, that's what happens? No. Mom Jorge to owner, I'm helping out Dad right now. Call you in a few. Owner to Mom Jorge, can you help me put out, fuck off? Jorge, Mom to owner, how? No problem. From 267-216-5170 to owner, damn, you can only talk when you're drunk and talking shit. Owner to the previously mentioned 267 number, stop calling, texting my phone, he's not here anymore. And it's damn. 267 number to owner. NP, you didn't have to be a bitch about it. Owner to 267. Going on to page 13. Still May 30th, 2019. Yo, I like you all. He's a dick and the sheriff just left. Sorry I couldn't text back. I'll always respect you all. You know that. He's not here anymore. And yes, I am a bitch. So are you. 267 to owner. Look, I'm not here to be taking shots at you. I never called you a bitch. I said you were acting like one. I'm not going to be here going back and forth on some childish shit. Have a good night. Owner to the 267 number. Friends forever, thank you. Would love to chat sometime.
Ew. So she treats her friends in the same way.
Call his parents, I guess. Further down on page 13, now on to May 31st, 2019, from owner to Mom Jorge. Tell Jorge to call me. I want my things he took. I have his birth certificate and propane certificate until then if he wants those back. And I have your quote-unquote art box. Mom Jorge to owner, stop being petty. I did not take anything that wasn't mine, I swear. Owner.
So she's withholding his property, accusing him of taking her property. Recall the video we saw when she woke him up. He's in bed sleeping. She wakes him up saying, "Where are my car keys?" and accuses him of taking them. And he's like, I didn't take your car keys. I don't know what you're talking about. Recall how he couldn't cash his check because he didn't have his ID because she withheld that from him. And as for the art box, it didn't come in at trial, but neighbors said to police that Jorge was an artist and a musician. He was an artist in his own right. So that would be something important to him, his art box. And not only is she demeaning it by putting it in quotations, she's withholding it. So I think the jury, because this is hard to follow, I think the jury's going to have to go back and really sort of plod through this line by line.
Owner to Mom Jorge, you're a liar. I never can believe you from all the other lies. You stop being petty and take shit like you always do. Another one bites the dust, Jorge. Hope you're miserable like you've made everyone else. Mom Jorge to owner, I'm not lying. Owner to Mom Jorge, Lucas said he won't miss you either. When I get mine back, you'll get yours. Mom Jorge to owner, I didn't take it. I'm coming over in a few to get my stuff, and I'm coming with Jean and Melissa. Going on to page 14.
Have any of you ever been accused of something you didn't do? I'm not talking about like a crime, but of, oh, you took this or you broke that or you said this when you didn't say that. And just the accusation just feels really unjust, especially if that's not the type of person you are. It feels really unjust. And to not be believed, I mean, that in itself is difficult. And now imagine being barraged with that day after day. You saw how she treated her lawyers and the accusations she leveled there. Just if you have a sense of justice internally, it really violates that. It's tough.
Owner to Mom Jorge, go for it. Bring mine W. Mom Jorge to owner, I don't have anything of yours. That's why I'm coming with them so they can vary that. Owner to Mom Jorge, I don't care. They're not going to babysit you because you're an asshole and got kicked out after being taken off the lease. Mom Jorge to owner, they seen what I had in my hands. Owner to Mom Jorge, still don't care or believe you. I'm going to get Lucas anyway, so don't waste their time or mine. Mom Jorge to owner, exactly. Owner to Mom Jorge, you were a visitor and a terrible resident, boyfriend too. Just go away unless you bring my stuff. Mom Jorge to owner, I don't have your shit, Sarah. I need my birth certificate. Owner to Mom Jorge, I don't give a shit either. I worked for that birth certificate, voter's registration, and your ID card. Just because your name is on them doesn't make them yours. Even paid for them. I needed you to be a man and take care of me, not beat me, call me names, and make me feel like I'm not a person. Not giving back until I have mine. Mom Jorge to owner, whatever, Sarah. Owner to Mom Jorge, next step is restraining order. Know that. You can come over here 100 times. Doesn't mean I have to open the door. Good one, Jorge. Go away. Mom Jorge to owner, whatever. Owner to Mom Jorge, it's been a great day without you. Will be from now on. Mom Jorge to owner, you need to do. Owner to Mom Jorge, enjoy living with your parents at 41 with no girlfriend and lonely. It was the inevitable, just like it has been before. Owner to Jorge, Mom, did you take Lucas's?
There is a difference between a discussion, a debate, resolving a disagreement with somebody who wants to actually resolve the disagreement. She wants to emotionally bludgeon this guy. So no matter how much proof he offers that he didn't take her stuff, it doesn't matter. It doesn't matter because that isn't her goal, is not to understand. Her goal is not to resolve. Her goal is to blame and to pound him down. And if you find yourself in a discussion like that where nothing you say is good enough, or somebody changes the goalposts on you, so maybe if you prove that you didn't take the thing, the person says, well, yeah, it's just like this day over here, you did this, and suddenly you're in a different argument altogether. And 6 months ago, you did this, and boom, like everything in the world that you thought was resolved is all brought up again. You know that every interaction you have is just fuel, it's just ammunition for them, because what they're doing is not actually trying to resolve the argument. And if your sense of justice has been violated and you're feeling blamed and you want to be exonerated, this is unfair, right? And they're gaslighting and they're doing all that. It's unfair and you want to make it better. You have to understand this. You will never get validation or fairness from somebody like this. So when he says whatever, it's like the resignation. He knows it cannot be resolved. So you can save yourself a lot of heartache by just not bothering to get into the weeds, because it's like, I don't know, it's like a hippo that drags you underwater. You can't escape it is when you engage.
Sunglasses. Mom Jorge to owner, OMFG, no I did not. Turning to June 2nd, page 15, 1:10:57 a.m. from owner to Mom Jorge. Jorge, question mark, call me. If Jorge is with you, can you have him call me, please? Text to Mo. (1:18, 16 seconds on June 2nd. Owner to Mom Jorge. I beat you to the punch. One, do the dartboard with me? Come. Owner to Mo. I know you won't answer, Mo. Tell him to come finish the dartboard with me, please. Owner to Mo.
And this is triangulation. So she can't get him. And you know what? She's contacting him. If this is during one of the times that there's a no contact order, now she's badgering him. And if he responds, he can be in trouble, right? Regardless of the reason why he's not responding, he's not. And this is an example of not respecting a no. And in threat assessment, that is a huge red flag. If the other person will not respect your no, even if it's a little thing, it's a big deal. So now she goes to other people to, it's like flying monkeys, right? To get them to get him to do what she wants. So she's pulling other people into this relationship. Another really bad sign.
I miss him. Owner to Mom Jorge. Ask Jorge to call me, please, when he gets a minute. June 2nd, 7:43:40 a.m. Can you have Jorge call me, please, when he gets a chance if he's with you? 7:45 a.m. Owner to Mo. Going on to page 16, June 2nd, 2019, 10:50 a.m., 55 seconds. Owner to Mo. Hello. Can you please have Jorge call me? Willing to give back. Don't know if he's there or at parents. Really want to see him. Owner to Mom Jorge at 10:52, 16 a.m. Not pursuing after 12 o'clock. Ever again. (12:19 p.m., 23 seconds. Owner to Mom Jorge. Please call. Come over. I'll come get you. Come over, please. I need a super hug. Hugs? Please, need. You. 6:23 p.m.
Here's an example of that power and control. This is an example that fits in with BSS, except he's the victim. He is not responding. If I don't answer you, if I ignore you, that is an answer, right? He is not responding. She wants what she wants when she wants it. And this is June 2019, so he was subject to an order, and she knew it, and she weaponized that order against him, by the way. So it is during that time. So he is not responding, and it's just harangue, harangue, harangue. And then there is what could be perceived as a threat, right? Not of violence, but a threat. Like, I'm not letting you go. I can come and pick you up. He may even worry that, oh my gosh, if I don't respond and go over there, she's going to come over here and it's going to be upsetting to my mom or my family or going to cause an issue here now at their house. That would be a reasonable thing for him to think. So, and she still has his ID. So, if he goes over there, if he responds, he's subject to arrest because he's the one subject to the no contact order.
Owner to Anna. He doesn't live here anymore. Call parents or Mo in response to an incoming phone call that was made at 6:10 p.m. 54 seconds from Anna to owner. Entries 9803, 9804 in the PDF timeline, June 2nd, 2019. Image 0092.heic, capture time 6:33:01 p.m. Image 0093 HEIC, captured 6:33:26 p.m. Publishing from attachments. Image underscore 0092, metadata showing 6/2/2019, 6:33 p.m.
I've got it. I'm holding it hostage.
And image or IMG underscore 0093, metadata, date taken 6/2/2019, 6:33 p.m.
I have words I can't say on YouTube.
(6:34 p.m., 51 seconds, June 2nd, 2019. Outgoing from owner to Mom Jorge. All up to you now, big boy. And for the record, those images were sent to Mom Jorge at 6:34 p.m., 33 seconds. Look what you made me do. Or maybe your mom will for you.
That is another common tactic of abusers. I am going to do something vicious, cruel, evil, abusive, and it's your fault. If you're out there listening, because I know there are survivors in the chat, if somebody has said that to you, if somebody harms you and blames you for it, they are wrong, not you. He didn't make her do that. She chose to do that. Not only did she choose to do that intentionally, there was a purpose behind it. And the purpose was to inflict pain, to cause harm, to be cruel. She had a depraved heart from the beginning, not just at the time of the final crime.
Response from Mom Jorge to owner. Wow, that's really childish. Owner to Mom Jorge, but effective. Mom Jorge to owner. Yeah, I see what you are doing. Did Lucas leave? Owner to Mom Jorge. I'm watching shadows. Be gone for good. Minus birth certificate. Mom Jorge to owner. Okay, cool. Enjoy. Owner to Mom Jorge. Am. Nice. You're not. And nice was from Mom Jorge to owner. Going on to page 17. This is still June 2nd, 2019. Mom Jorge to owner. Yes, I am. You are not, though. Owner to Mom Jorge. To who? Your mom? Brothers? Not me. Mom Jorge to owner. To everyone. Owner to Mom Jorge, but me. Mom Jorge to owner. I love you. Owner to Mom Jorge. I'm going out at 8. Get dressed. I've given you since noon. Peace out, Boy Scout. Mom Jorge to owner. I'm coming over with a handle. I was helping Pop all day cut grass. Owner to Mom Jorge. Yay you. Getting in the shower then out. Bye-bye. Mom Jorge to owner.
Excuse me, can we approach the bench?
Yes.
Someone said this is full-on stalker behavior. Yeah. It
Objections
is.
overruled.
I'm already showered and dressed. Mom Jorge to owner. Hello? Text from Anna to owner. You're rude as hell, but okay. Owner to Anna. Your dad is a POS, but okay. At least you know and will stop calling. Owner to Anna. Futile. Anna to owner. CTFU, as you are a piece of shit, but that's God's business, not mine. Have a good day, coke whore. Since you like to switch it up, I'll do the same. Don't text me back either, fake ass. Page 20 of 108, June 9th, 2019, from owner to Philip. He's off the lease. The process has begun. Page 22, June 11th, 2019. Metadata only shows to Mom Jorge. You tell your son he's not welcome here, taken off the lease and bound, worthless. Don't show his ugly, fucked up face around here again. Police will be called. Ask him if it was worth it and ride my bike he has. Stay Hispanic, that's what you all are. And he can watch all the porn he wants from the phone Mom gave him.
Hispanic, as if that is a bad thing to be. That says a lot about who she is, doesn't it?
Page 26, June 14th, 2019, 11:38:56 p.m. To Mom Jorge. Wow, congrats, blackouts and whoring. We wanted to see him. Hot house, 7 people. Mission to work on my bike. Repeat. Candy Crush. Fuck himself. Shit job. Repeat. Same page, June 15th, 2019, 7:37 p.m., 48 seconds. To Melissa, just an FYI, if my place gets effed up, I'm letting you know. He's in jail. Thanks for the prompts. I'm at my ex's house. Please don't let this reflect on me as a tenant. You said to call cops. I did. He's gone. We're both proud now. I consider you my friend. Melissa, why was he in your apartment? Page 38, notes, creation time, June 26, 2019, 5:56:57 a.m. 6:14, X videos, 10:03 a.m. Sarah Banks, 5:3 Bank, 6:13, Metro Activation 6:12. Skipping down, X videos, 6:2, 6:13 p.m. X videos 6:1. X videos 5:31, 9:56 a. Who's Christine? Paren FB. Going to meet up? Question. Calling her beautiful? Question. Said she thought you were avoiding her when down here. Said no, I was not beautiful. FB-nonchalant Quay. Thanks for adding me. You are exquisite. Facebook messaging Camille 613 942. Facebook or FB Pamela Erickson sending pictures of yourself, telling her good morning 7:14 12:13 a.m. FB Crystal going to woo her.
I just thought of something I wanted to remark on here. Sarah has used God or the name of God and acted like she is a person of faith, right? And it doesn't matter what religion you are. I'm just going to say person of faith. But in her, what she says is her faith, part of the definition of love, so that would be 1 Corinthians 13, is that love does not keep a record of wrongs. And here she is, making sure that she is recording every single detail so she can go after him for it.
Sweep her off her feet, going to change her mind. Luck is my middle name. Sent her pics, kiss emojis. Called her beautiful after returning to the convo. Said you had to pick up your brother. Sent pics of beer. Sent her struts, could have been me. Sent her songs, but not me. Messaged bunny kiss emojis. Convo. Sent puppy kiss emoji. Would love to take her out and see a movie. Told her about what we do in the shadows. Would love to watch Creed 2 with her. Want to snuggle with her and eat popcorn. Sent heart-hugging animal emoji. Want to play a board game with her. Asked to FaceTime call her. Called her amazing. Messaging at 7:30 a. 6:14, 6:15, 2 days. FB-Crystal liking all her posts. Quote, losing someone who doesn't respect or appreciate you is actually a gain, not a loss. Can't compare me to the next girl because there is no competition. I'm one of a kind and that's real. Continuing on to page 39, same note. I found everything on your phone, all your messenger texts, telling Christine you want to meet up with her when she's here, calling her beautiful, thanking nonchalant Quay for adding you and calling her exquisite, telling Pamela Erickson good morning and sending pictures at 12:38 a.m., messaging Camille, then the whole 2-day convo with Crystal, how dare you, and send pictures wearing my wedding ring. You're a cheating, lying scumbag. I will never trust you. Why don't you put your mugshot up, or I will, since I have your phone, and log in and tell everyone why you were in jail for the 3rd time. Let them know you beat your wife and she put you there because she couldn't take it anymore.
I have your phone and log in.
I want nothing to do with you ever again. I've become a different person since you've been gone, with less stress, anxiety, and worry. I feel safe, comfortable, happier with you not here or seeing you at all. I can say through I do have heartbreak after going through your phone. Thank you for always proving me right. I knew when you told me your mom gave you one that you'd be back to your slimy ways. You will never change. I hope it was all worth it, all of it, including losing my debit card for the 3rd time to buy beer and cigarettes, which put you back where you belong. I know for a fact you were not worth any of it. I just can't believe after everything I've done for you, including all I did to get you out of jail, and you do this to me. This is cheating. Goes on to page 40, goes on to page 41. and ends with never truly yours. Page 42, June 26th, 2019, 8:06 p.m., 16 seconds. Outgoing from owner to Mo. Just wanted to let you know to tell Jorge I found all his messages, kissy face heart emojis with Crystal and other bitches on FB, along with all his porn after he swore to me he wasn't doing any of that anymore. I'm not doing anything more for him, and he will try and keep him in jail as long as I can. Cheating snake weasel. Ask him all about it or have your parents the next time they talk to him. I'm not anymore. So hurtful after all I've done for him. He can rot in there for all I care.
And will try and keep him in jail. Not for a crime he committed, but because I'm ticked off at him. Because he didn't do what I want. There is the evidence right there.
Going on to page 43, to Mo from owner, and I will be there for the hearing next week and his arraignment on both charges. Peace out, fucks, aka Torres. Same page 43, from owner to Mo, 6/26/2019, 9:59:14 p.m. Begins, hi, I was thinking if you could get out, I'd really love it if you'd take me to a movie, or we could snuggle like we do and watch Creed 2, get some popcorn and pretzels, maybe talk about what kind of other movies we like, or find a fun board game to play together. I know your favorite is Abalone. What do you think?
Whoa. I didn't see that one coming. So this is between her and Brian. So when they watch movies, they snuggle. So she's playing with him that way. So she's playing Brian too in that way. Whoa. I'm sorry, I didn't see that.
I was also thinking the other day about how much I miss you sending me pictures of yourself throughout the day, sending me songs you wanted to hear or thought I'd like, but what I really miss are the kissy love emojis you would send just because I really miss those.
Okay, wait a minute. Maybe I got this wrong. I might have just said something wrong. No, I didn't. Wait a minute. No, it's Mo. It's not Brian. It's Mo. Okay, is she... I'm sorry, you guys. I'm confusing my own self. So is she talking really... I don't know. She's talking to Mo? Or if I think she's trying to talk to George through Mo's phone. That's what it looks like. So just ignore everything I just said a minute ago because, like, sometimes I'm an idiot.
I was also thinking the other day about how much I miss you sending me pictures of yourself throughout the day, sending me songs you wanted to hear or thought I'd like, but what I really miss are the kissy love emojis you would send just because I really miss those, especially the ones with hearts. They'd always make me smile. I knew you were thinking about me. You do Crystal, though. Even asked her to FaceTime. What would you do if you found me having this convo with Ben or John or anyone other than you? I'd be beaten to a bloody pulp. And don't do any of these things anymore, but yet you wear your wedding ring and mine around your neck and tell me how much you love me. But you're telling this woman who looks like TPT you want to snuggle with, take out to a movie, play board games with, questions, sending music, cutesy, kissy love emojis to like you used to me, telling her you want to woo her, sweep her off her feet. How do you think that makes me feel? Why don't you say that to me? Going on through the rest of page 43, page 44, including on page 44, dirty cheat, enjoy your porn and jerking yourself off secretly so your parents don't see you and your ugly new girlfriends. I can't wait to finally be with a real man, Ben, who will and has taken care of me. Can't wait to see what he's like in bed. I already know he kisses. Hope it was all worth it. I'm free. As you told Crystal in your messenger text, you're single with a little cutesy dancing dinosaur. Wow, now you really are. You're despicable. Next text is XOXO.
Sorry, someone in the chat saying they're confused, and I may have added to the confusion. So I'm not sure what the confusion is. So it seems to me that this conversation is between Sarah's phone and Mo's phone. Mo is George's brother, but based on the context of what is being said, it looks to me like Sarah is trying to talk to George. George doesn't have his own phone, so she's trying to talk to George through Mo's phone here. So she's talking to George, but using, through Mo's phone. Does that make sense? And then the other, okay, Mo is the brother. Is Crystal the daughter, Jorge's daughter? And, she's using, I got another guy who's going to take care of me. And that tells me that it's not Mr. Torres, who was like so distraught over losing his job. She was using him financially as well, right? She was using him financially. He lost his job, and not long after that, he's gone, right? And her priority is to find a man who can take care of me. That's what she's looking for. And all of this, blah, blah, blah about how wonderful she is and all this stuff and stress over money, it seems to not occur to her to actually hold down a job. She did get a job at one point and didn't last very long.
From Mo to owner. Page 50, 6/28, 2019, 10:55:47 p.m. From owner to Mo. Just know, I can do so much more damage than all of you put together. Know that. Going on to page 51. Try me. Page 72, July 20th, 2019, 11:34 p.m. From Janice to owner. No metadata, but from Janice. Sorry it's so late. I just read your text. He seemed fine when I saw him at your apartment this morning. He answered the door right away, but was quite bummed out that he overslept. But I was okay and told him, no problem, just get ready and come to work in about half an hour. Then I texted your phone and asked if he would rather work the afternoon shift and get some sleep, but he never answered, so I have no idea where he is or what he's doing. What happened last night, he had a black eye. He said it was new because I asked him and I told him to put makeup on it. He said he had that taken care of. Did you two get in it again? He acted like when I told him he had a black guy At first, he didn't know what I was talking about. I guess he kind of blacked out. You can call me back if you want. "11:30 p.m., 38 seconds. From owner to mom, Jorge. Janice just called me looking for Jorge, and she's pissed. Congrats." Page 82, 8/21, August 21st, 2019. From Jorge to owner. "I love you, my friend, my love, my queen, my everything." Your Honor, that concludes everything I'm going to publish to the jury on this exhibit.
Okay.
Judge, will we approach the?
Yes.
I'm going to fast forward past the approach. I think the jury's going to have to actually sit down with a hard copy of those papers or the computer and really go through and make sure that they understand who's speaking. I can't remember how many pages there were, Cookies. It was a lot. Marco Barco thinks the jury is not confused. Someone's asking, is Sarah capable of remorse? I don't think so. I think she's sorry when something affects her. Colette thinks that this is not very effective. Mr. J is too dry, and I don't get what his point is. His point is to illustrate who she really is. Oh, there's his family. Look. If you're not looking, look. Oh. It must be so hard for them to hold it together. Oh, is that his? Oh, I thought his mom was there. Oh, yes, she is. And they're literally leaning on each other. I want to cry. Wow. I totally lost my train of thought. Oh, yeah, somebody was asking about what's the point. The point is to show what she's doing. She is not letting him go. She's not respecting his boundaries. She is psychologically abusing him, withholding his property, using the law against him, threatening him. I mean, the list goes on and on and on, right? She is bringing in other people. She even somebody at work ended up calling Sarah to say, well, he had another black eye. He had a black eye. So it's just so much in there that shows really the dynamic was he was the one trapped by BSS. She may have displayed elements of that in front of the psychologist and the psychiatrist, perhaps. But you know, all of this is a pattern and it's classic. Oh, someone in the chat saying his brother looks so much like him. It might be humanizing him more for the jury. Yeah. Yeah. Mad Mystic is saying if I was on the jury, I'd want to cross-reference some of those notes to the no contact order. Yes, my thoughts as well. Mia Speaks TV says, look at her. She's all anger and no empathy. Yeah. Have you seen her show Grief for Him even one time? Aaron says even without the text.
Members of the jury, the state jury, thank you for your patience. I just have a short instruction to read to you. Members of the jury, the state showed you portions of what was entered into as State's Exhibit 21. It is not the entirety of State's Exhibit 21. The entirety of State's Exhibit 1 will go back to you into the deliberation room with a laptop for you to review all the exhibits and text messages and the total conversations over and above what was highlighted by the state. With that, State, do you have any other witnesses, evidence, or testimony to provide?
Your Honor, at this time, the state rests its rebuttal case.
Okay. Anything further from the defense? You want to approach?
I just think we have some issues outside the presence of the jury that we need to address.
Okay.
I have one thought, though, that requires a quick vote.
Come on up.
Colette saying, I agree with the cross-referencing comment. Hope Mr. J does that in closing. Yeah, I don't know if he will. I mean, I could talk for 3 days about all that's wrong here, right? So could you. Yeah, the brother is wearing George's Ace t-shirt. I think that's great. George was proud of that. And somebody said something in the comments, made the point that, look, the guy had a job. So Sarah was denigrating him. You know what? I don't care how menial your job seems to be. It's a job. If you're making an honest living, then that's good. That's good. I mean, I wouldn't criticize anybody for their job. You're making an honest living. He worked. He went and worked. And in her interrogation, there was a clue there where she said, yeah, he tries to help out, maybe pays
All right,
the
members
odd
of the jury,
bill.
we're going to go ahead and excuse you for a couple minutes. I got some things I have to discuss with counsel outside of your presence. We'll bring you back in for additional instructions on where we think we're going to go after that. Similar instruction that I've given you over the last couple of days. Please do not conduct any independent research or investigation with regards to the persons, places, things, or charge involved in this case. And do not have any discussions amongst yourselves or anyone else about them. We'll bring you back in as promptly as possible. Thank you.
Yes, Frauke, he was proud of the job.
The state has rested. Mr. Owens, do you have any intention on putting on a sir rebuttal in this case, sir?
I could have one more.
Yes, sir.
True crime boozer is saying, yeah, well, we have to attend to another bit of nonsense from Mr. Owens. Yeah.
We do not intend to put on a solo rebuttal for the defense.
Okay, thank you. All right, Ms. Boone, I've got a couple of questions to go over with you, ma'am. You were previously sworn this morning. You've had the opportunity to review and participate in the trial. You've had the opportunity to review the rebuttal case as provided by the state. You've had the opportunity to review and listen to that evidence and witness any cross-examinations as it relates to the state's witnesses in their rebuttal case. Are you satisfied with your attorney's representation of you in this matter?
Definitely.
And are you still on board with the strategy that has been utilized in your defense?
Yes.
Now, your lawyers yesterday told the court that they may want to put on a sir rebuttal, which would be a limited rebuttal to the evidence presented by the state in their rebuttal, both yesterday and today. Your lawyers have indicated that they do not intend on doing that. Similar to other conversations we've had, ma'am, I don't want to know specifics. I just want to know if you and your lawyers have had these conversations. Have you had a conversation with your attorneys about putting on a sir rebuttal? or
Yes.
a reply in response to the state's rebuttal?
Yes.
You had that conversation.
Yes.
Are you on board with the strategy employed by your lawyers that they are not seeking to put on a sir rebuttal in this case?
I am.
Okay, all right. Is there anything else that we need to address, state?
No, sir.
Judge, you remember you were going to speak?
Yes, thank you, sir. Ms. Boone, at the conclusion of the state's presentation of State's Exhibit 21, Mr. Owens had approached and had advised the court of some objections, specifically with regard to the co-ownership or co-usage of the phone. The court is not permitted to comment on the evidence, and your lawyer was seeking an instruction from the court to advise our jury that both you and Mr. Torres had access to that cell phone. I am prohibited from commenting on the evidence. Now, that doesn't prevent your lawyer or the state from speaking about that in their closing arguments. Just as a matter of law, I am not able to advise the jury as to what that evidence is. The second request pertained to the state moving from place to place through those 108 pages, moving from timestamp to timestamp. The state chose to present that evidence in that manner, which is why I gave that instruction to the jury that not the entirety of Exhibit 21 was provided to them as to what the state produced, and they'll have to have the opportunity to review that in its entirety when they go to deliberate. Do you have any questions about that so far?
So far, no.
Okay. The last portion, ma'am, pertained to the cadence or tone in which you and Mr. Torres communicated with each other. I have no knowledge as to how you and Mr. Torres communicated in text form as to what the tone was behind those words. Your lawyer advised me that there was an objection and you had some concerns as to the way Mr. J may have read those text messages to the jury. I found that the way that he...
Honey, it's a good thing that Mr. J read those text messages, because if I read those text messages, you would not have liked the tone. Wow.
He read them was benign in a flat tone and did not exacerbate or excite any of the language that was in there. He had read them in as a monotone way as possible in presenting to the jury, and I didn't notice any changes in his cadence or heightening or lowering in the volume or tense or tone utilized in presenting that information to the jury. Do you have any other questions for me, ma'am?
No.
Anything else we need to address, Mr. Owens?
No, sir.
Anything else we need to address, State?
No, sir.
Okay. How would we like to proceed with the charging conference? Do we want to bring back on our jury? It is 10:33 and advise them this is when we think you want to come back because we're going to be addressing the law to provide to you, and that's something I need to do outside of your presence. How do we want to proceed at this time?
I think, hopefully, at 10:33 to about noon should do it for 3.6F. It is convoluted, but I think the parties have narrowed it down to really just a couple of things.
Okay.
So I would suggest saying something along the lines of, we have to finish up getting the jury instructions ready for you. That's something that we have to do now after the evidence is concluded, and we'll see at 1.
I say 1:30, Judge, in the abundance of caution, because Mr. Henderson, I know this is going to be an issue, and it's going to take a little bit of time.
I say 1:30, Judge, because I'm going to be a pain in the arse, and I'm going to, stand up and say a whole bunch of unnecessary words that don't necessarily make sense and talk in circles. That's why, Judge, we need another half hour.
And then we want to go to lunch and give them a chance, because there's going to be a 3-hour speech session. I don't know if you give them a break in between prosecutor's statement and my statement, or how you do that.
We may, depending on just the time of it.
But from 1:30, that's going to go to 2:30, 3:30, 4:30. So just before 5, I think that's plenty of time in case he goes a little bit longer or I go a little bit longer.
And I still have to read the jury instructions as well. So, with 34 pages, and I read quickly, as Madam Court Reporter will advise me.
Are they going to have
Yes.
you reading along with you?
Yes. So once we make all these changes, every member in the box will have a paper copy. You, Mr. Owens, and your team, along with Ms. Boone, will have a copy. The state will have a copy. Madam Court Reporter will have a copy, and I will. And I will read line by line all the way up into the 2.7 instruction. At that point in time, I will stop. I will advise our jury that we're going to begin with closings. State will go, you will go, state will have an opportunity for rebuttal, and then I'll finish with the verdict and final instructions. Discharge our alternates at that time. I'll go back and thank them and give them their jury certificate forms, and then we'll release the jury. I'll have a final colloquy with your client, and then we'll review all the evidence to send back with the exception of the baseball bat.
And perhaps in case they haven't inferred, let them know that they're getting the case tonight, so make plans to stay later.
Yes.
How late are you going to keep them?
9 o'clock is the norm. I may, because it's the weekend and it's Friday, I may seek special dispensation from the chief to stay longer. I plan on communicating with the chief during the lunch hour as to that issue,
I think that would be great.
if she'll let me. I don't know if it's at her discretion. I know I have to seek approval after 7. I'm not worried about that. I know, and I would prefer them to work late into the evening if they're on board with doing that, rather than coming back Monday. Okay, all right. If you all would be so kind to give me a moment so I can go back up to chambers, get with Ms. Barrios, and I'll give paper copies of everything from the revisions that we made this morning. Let's go ahead and bring back in our jury. And I agree with Mr. Owens. I'd rather us waiting on them than them waiting on us. So I think 1:30 is the way to fly. Let's go ahead and bring back in our jury. As our jury.
Yes, I do.
I thank you. Y'all can be seated. Members of the jury number 2 in the back, he's ready. He gets it. All right, can you raise those hands one more time for me? All right, record reflect. Hands have been raised as compliance with regard to the court's instructions. Members of the jury, all the evidence and testimony sought to be provided by the state and the defense have been provided to us over the last week. At this point in time, the state and the defense and I need to discuss the law to be given to you in instructions. That's going to take a little bit of time. So we're going to go ahead and excuse you at this point in time for a longer lunch break than what you've had previously. And we're going to ask you to come back here at 1:30. At that point in time, the court will begin to instruct you on the law that you are to apply in this case. Then the parties will begin with their closing arguments. The state will go first, then the defense. Then the state will have the opportunity to rebut any of the defense's arguments. After hearing the closing arguments, the court will provide you final instructions before releasing you to deliberate in this matter. We may work past 9 o'clock tonight. We may go late into the evening. So if there are any plans or things that you need to reach out to, as we discussed last week during jury selection, that we could work till late as 9, and we may work later than that this evening. If there's anyone that has any concerns as to working that late, please raise your hands at this time. Court sees no hands. I would also ask of you, if you could, please reach out to any family members or friends to, one, advise them that you're on the jury and will be deliberating this evening. And if there's any accommodations or issues with minor children or family that need to be taken care of, I would ask you that you take care of that during our lunch break.
And the emergency phone number, since they won't have phones.
Yes, we will provide you. The court deputy will provide you the emergency phone number when we get back from lunch so that you can provide that during a break that we'll have this afternoon to any friends or family or loved ones if they need to get in contact with you. I will give you a similar instruction that I've given you over the last couple of days. I know you're probably tired of it, but I got to give it to you one more time. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors, do not watch local news or read local newspapers. Jurors must not have discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again that just as you must not talk about this case face to face, you must not talk about this case by using an electronic device. You must not you must not use phones, computers, or electronic devices to communicate. Do not send or accept any messages related to this case or your jury's service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, I thank you for your attentiveness, service, and sacrifice, and we'll see you at 1:30. Juror number 2 in the back. Yes, sir.
Question. So
Answer.
with the parking, we're going to be here for some time. Can we leave and come back and get restamped with a new thing?
We will have you that answer when we come back.
Okay.
Madam Clerk's going to figure that out for you.
Okay.
All right, thank you very much. Well, I've been advised by double speak. Could you do that, Officer Jones? I've been advised by, rather than double speak, could you just tell me what it was? Say it for the record what it was.
If judges approve that they are to go off campus or out of the courthouse garage, they can come back and get new stamp cards.
So they can leave this point during lunchtime. Okay.
And
Oh,
I'll
they're
approve
talking
that.
about parking.
So, State, anything else we got to discuss other than the jury instructions?
Nothing else.
Defense.
Oh, yeah.
Okay, court's going to run upstairs, put the finishing touches on what we agreed to this morning. I'll bring back paper copies for everyone, and then we can continue the charging conference. At that time, court's going to be in a short recess. We'll be back as promptly as possible. Thank you.
Okay, so here's what's going on. So the jury has been excused right now because the lawyers still have to finish the whole charging conference. So all the language of the jury instructions and all of that. So they're still going to hash that out. I expect that Owens is going to have, or the defense is going to have issues during that there's going to be some discussion and some debate. Then when the jury comes back at 1:30, hopefully, if everything goes well and we start on time, the jury's going to come back at 1:30, and there will be closing statements. After closing, this is what I think is happening. After closing statements, then the jury will be provided instructions on the law and, the usual, and they will be sent to deliberate. They usually are allowed there to deliberate till 9. The judge is saying he may be able to get permission to deliberate longer, and they all seem amenable to that. I see people in the chat are saying, oh, we're getting a verdict in 2 hours. Remember that the jury still has to review all of the evidence. And we have had hours of interrogation. They just were given a 100 and something page document anyway, full of text that they haven't completely read, that they're going to have to sit and go through. They haven't been able to talk to each other throughout the trial about the evidence. So they're going to have to sort of get together on even what they think so far, discuss the evidence, and then start, deliberating, going, okay, do we understand the law? Here are the elements that have to be proved, et cetera, et cetera. So it's going to take a while. Somebody is asking, will we be together for the verdict? I would like to be. And so I want to hear from you how to handle that. So I'm just going to push that stream forward, and I'm going to switch streams. Switch screens so that I can get a bigger look at this chat. Lisa's saying if Sarah were to be found not guilty, she'd go back to drinking and all the same behavior. She is who she is. She has not changed post-arrest. She was that way before she met Mr. Torres. So absolutely, her behavior will be the same. And she's shown no interest in changing or taking responsibility or anything. So how do you want to handle the jury, the verdict watch. Do you want me to? So I can do this two ways. I can all of a sudden just go live when a verdict comes in, but that means you might miss that because sometimes the notifications don't go out. I can leave the stream just open and just put up a, court is on a break or something to, and then the chat's still open. And then if you're just listening, then when a verdict comes in, then you can hear me. Like, I'm not sure how you want that, how you want me to handle that with the stream. If I just leave the afternoon stream open, think about it and let me know. You don't need to tell me right this minute. Tracy says people can change, but people who are dead inside, like Sarah, cannot. Yeah. So the somebody suggesting in the chat a 2.5 hour break, possibly. What's happening now, though, is we're just waiting for the judge and the lawyers to come back to finish hammering out the jury instructions. So that's what we're waiting for right now. Somebody's saying she's not grinning today. Quiet Knitter said is leave the stream open with verdict watch graphic. I didn't think ahead. I didn't make a verdict watch graphic. So maybe I can make one. Even if it's just like text, maybe I could do that. Frauke, what does Watson say? I would be there with you no matter how long. I'm inclined to, so in the afternoon stream, that it's a separate stream from this one. So I'm inclined to hear the closing statements and then chat with you guys for a bit and then just leave the stream open so that people who want to continue to chat can do so in the chat. And because I know some people are just listening, they're not watching. So then when the verdict comes in, those who are just listening will hear the sound and will know to listen. So I would love for all of us to see this together. So it could be a long night, but I can't stay on the stream. Like, I can't talk for that many hours. Like, I just don't. I don't know. I could read books to you, maybe. I don't have that much in my head to be able to talk that long. Oh, Cookies makes a good point. Cookies is saying leave it open. There could be jury questions. Yes, good point. Criminal Minds is saying George's oldest daughter and sister will be interviewed on Court TV. I did see that. That will be interesting. Oh, somebody's saying it helps my healing to chat and listen. The chat is full of victims trying to find normal life again. Yeah. Yeah. Okay. I think I am going to leave the afternoon stream open for people who want to chat in case there's questions, but I will not sit here for that many hours. Like, I won't constantly sit here. Watson needs to be taken care of too. West Rocker is saying she dragged George's family for 4 years. It's time they get to see Sarah put away. Yeah. Beryl's saying we need to be together. Okay, I'm going to leave the chat open. I'll leave it open. So that'll be this afternoon's stream. Lizzie's saying, I'd love to talk about other cases you've covered too, like Shonda. Yeah, that one triggered the crap out of me. I got, my mind was brought back to the Shonda Vander Ark case when we were watching George on the floor like that, so emaciated and beaten down and being treated worse than a dog. Jessica saying to the rest of the chat, I appreciate everyone treating each other nicely. That you guys, this community is great. Yeah. And that's you. That's not me. Oh, Frauke is saying put on mods. Yeah, I have it subscribers only. Moth's mummy says play a loud trumpet or something when the jury comes back. Yeah, I think some people would not be happy with me for doing that. Oh, Mad Mystic saying, I heard Mr. J will have the Matty Soto case. Interesting. I wish I could get the documents on that. Local Art Witch is asking, will the jury deliberate over the weekend? I believe they will not. They would be recalled on Monday, is my understanding. Tevi saying, this is a wonderful, empathetic community. Yeah, you guys are great. JSS is asking what I think happened with the financial issue with the defense lawyers. So the comment is they never revisited that, but we don't know that. We don't know that they didn't have that discussion in camera. We don't know that just because it's not public, right? And I can't comment on anything other than the public document. So I really don't want to speculate on that. I think it would be irresponsible of me to do that. It's a Duck says verdict won't take long. Tillman's asking, is it too late for her to take the deal? It better be. Someone saying, yes, Soto case is too much for me. Yeah. That's brutal. It's brutal. And you know, the way YouTube is, like, my videos get demonetized sometimes even when all I'm doing is educating, right? So it's frustrating. Anna Shaw, can she get life? I think so. Robert Green says, must be getting real for Sarah now. Yeah. I don't know. I think she's going to be in denial to the very end. I think if she's convicted, she's just going to scream and cry. It's not fair, not intentional. You didn't understand. It's the judge's fault. The judge was not fair. My lawyers were not fair. I mean, that's her. Hello? Oh. They still have to go through all the evidence, though, again, right? Kim, I know Gazelle at Grizzly True Crime does have documents. She is a class act. I also know she's very busy, and I don't want to be pestering other creators. Oh, give me the benefits of your hard work when I know you're busy. So I'm just sort of, yeah, I know she probably would, but because she's nice, but I don't like to bug people. I need to figure out how to get that stuff myself. Somebody saying, yeah, or Sarah will say the jury was rigged or biased. Yeah. Jane, do you think Cranick is going to give her a long time in prison if she's convicted? Yeah, I think so. Yeah, I think so. I mean, I don't know what his sentencing record is like. I know that when you're working in a jurisdiction, you know the judges. I mean, you give them nicknames based on, sometimes based on the way they sentence. So, oh, this judge will sentence you really hard, and that one will find reasons, will find mitigating factors and all of that. So I don't know Kranick's sentencing history, but there are guidelines he has to follow. Isabel saying leave the stream open. Yep, that's what I'm going to do. CGC Vinyl says, I'm really surprised that Brian wasn't recalled. I think the information that he would have got out came out through the expert witness under Owen's questioning. So I think that's all that needed to happen. It was Owens who got it in there by accident. That was funny. Four of Cats is saying Maddie's case is too much for me. Yeah. Thank you, Aaron. Says looks like they're going to include a lesser offenses, so technically the deal is on the table. No, the deal is not on the table technically. So you have to include, so it's lesser included offenses, right? So the deal was a specific sentence though for that plea. So even if she's convicted of a lesser included, she's not getting the sweet deal in terms of sentence that was previously offered to her. And I don't think she should. Yeah. During her colloquy, Sarah confirmed her understanding of the consequences if she didn't take the deal. Correct. She knows. Holly's mom is saying, I can't wait to hear the judge speak to her at a sentencing hearing if she's convicted. Delane says, I thoroughly enjoyed this chat. I think a lot of people do. You guys are great. I enjoy this chat with you guys. Oh, Brenda says, I think the prosecution offered it knowing she'd refuse it. Then they can ask the judge to give her the max. Very interesting. Interesting strategy. They do have her number. Susie says, I bet her attorneys already have their notice of appeal prepared. Yeah, maybe. So, are we not coming back for the charging conference? Like, how long have we been on break here? I'm not sure whether to, log off for lunch or for a long lunch or not. I thought they were going to air the rest of the charging conference. Lizzie M is saying, yeah, they won't get far with an appeal. I don't think so, but I'm not an appellate lawyer. So, I don't know. That's a whole different world. Which Kranick would say, you're going away for life, know that. Or have a good day. Intentionally. Imagine we need Watson t-shirts. Mad Mystic. The best thing about this verdict is never hearing Owen's voice again after this is done. Thank you, John, for your comments. Yeah, Cookies is saying she'll have to have an assessment report done by the jail and other things for the judge to use to decide on sentence. Yes. So if she's convicted, the sentence isn't going to happen today. And the judge, I thought, was very patient with the way Owens treated him at times. Yes, Beryl's saying, love how the judge asked Sarah every move if she's happy with their lawyers. Yep. Cookies is saying that you think they're just late. So, okay, we'll wait a little longer. Lizzie Owens. Oh,
We're
here we
back
go.
on the record, 2020 CF 2603, State of Florida versus Sarah Boone. Let me get appearances for the state.
Dave Ketchner on behalf of the state. William J. for the state.
Defense?
Tony Henderson for Sarah Boone.
Kevin Mack on behalf of Sarah Boone, Your Honor.
Okay. Where might Mr. Owens be?
Judge, Mr. Owens is doing some preparation. I am handling
Okay. If the state and the defense can approach, I have paper copies of the revised jury instruction. You'll see on the bottom of each page is a file and path name. That's just for my own edification of where I've stored them, so then we make additional changes. The revisions that we discussed earlier today have already been made. There's still a couple cleanups that I need to do just to get rid of the formatting items, but all the revisions that we spoke about this morning have been included. With that, I think that takes us to page 9 of 28 in the 3.6F instruction. I also have the defendant's revised portions as to 3.6. Just for the court's clarification, is what is in page 9 of 28 of what was provided to the parties, is that the same as the separate defense 3.6F instruction?
Yes, Your Honor, it was only provided for more convenience for you to copy and paste them.
Got it. Okay, so should we be relying on the 3.6F instruction you, Ms. Henderson, sent last night?
Yes, sir.
Okay, all right. State, do you have that?
I have a digital copy, that's fine.
Okay, all right. Tell me when you have it pulled up in front of you, sir, and then we'll...
It's pulled up, and I had sent everybody the state's digital copy as well.
Okay, very good. All right. Let me pull up the digital copy that I have. Give me a moment.
Yes, sir.
Okay. All right, the court has the 3.6F instruction as provided by the defense. As to the first paragraph, it is a defense to the crime, bracket S bracket, of second-degree murder and culpable negligence if the actions of Sarah Boone constituted the justifiable use of or threatened use of deadly force. What say the state as to this instruction? And should not manslaughter be included?
It should be second-degree murder, comma, manslaughter, and culpable negligence, even though culpable negligence doesn't involve an intentional act. But I'm not going to fight over that.
Okay. Any objection to that addition?
No, Your Honor.
Okay.
Judge?
Yes, sir.
Can I interrupt for just a minute? Because there's a special instruction that the state is requesting on causation.
Yes.
And that goes, it's going to come before the self-defense.
When it was used in the previous case that I cited, that I used it in 10, 12 years ago, it's part of the instructions in second-degree murder. Yes, is where I would be requesting it.
And this is just so that we're all on the same page. Forgive me. This is the state's request for special jury instruction on causation.
Yes, sir. I suggest we table that for now and just get into self-defense.
Okay, all right. So we'll revisit the state's request at that point in time. So is the first full paragraph is read? Is that acceptable to the defense?
Yes, Your Honor.
Okay. Moving now to the deadly force definition. It seems.
Somebody in the chat is asking if the jurors who saw that DV display are going to be removed. The answer is no. It was dealt with. They didn't participate in it. It was a nothing burger. The defense and prosecution are on board with that. It was a big nothing burger. They just had to check and make sure. So no, there's no issue.
To track the language of the proposed jury instruction completely. Any revisions to that state?
No, sir.
Defense. It's your instruction, so I'm assuming you've got no quarrel with it.
No, Your Honor.
Moving to the next paragraph, I also believe that that's from the Form 3.6 instruction. State, any issue with the third full paragraph?
So in my request, I struck through or threatening to use each time because the evidence doesn't support that. What the evidence supports is she did actually use force. It wasn't a threat of force. So I think it's unnecessary and confusing and not supported by the evidence to have that clause in each of the paragraphs where it's mentioned.
Response, defense.
Judge, I have no problem with that. I was just, when I put it in, I just was going on some statements that the state had made in different arguments. So, especially when I'm talking about aggravated assault.
Okay. So just so that I'm clear, you've got no objection to the removal of that language. So the third paragraph would now read, Sarah Boone does not have the burden of proving that she was justified in using deadly force. Instead, for you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah Boone was not justified in using deadly force. Is that correct, state?
Yes, sir.
Is that correct, defense?
Yes.
All right, very good. Yes, sir.
To make it quicker.
And Mr. Henderson, you don't need to stand up every time, sir. I appreciate it.
I'm sorry, but it's old.
I get it.
I apologize. But it's out of habit. Judge, every time that comes up,
You lose it?
yes.
Understood. So then just let's go back to the title then. Can we revise the title to 3.6F, justifiable use of deadly force, and remove that bracketed or threatened use language?
It should just be used.
Okay, very good. All right. The next sentence, the law on the justifiable use of deadly force is as follows. Is that acceptable? State.
Just the strike through or threatening.
As I read it, yes.
Yep.
Is that acceptable defense?
Yes, Your Honor.
Right, moving now, Sarah Boone was justified in using deadly force if she reasonably believed that such force or threat of force was necessary to prevent A, imminent death or great bodily harm to herself. Is that acceptable to the state?
It's acceptable. Just confirm that they don't want me.
Yes, confirmed, only would be read would be A.
That's correct.
Okay, all right. Is that acceptable, state, with that understanding?
Yes, sir.
Okay, moving now to the next portion. Sarah Boone had no duty to retreat before using deadly force. I mean, my review of the case law, and I don't recall which one it is that if you're on your own home, you don't have to retreat.
My understanding of the facts was that she used force first by zipping him up in the suitcase and doing so that, one, she could make him feel like he had made her feel in the past for choking and cheating on her, and two, to give her a platform to be able to speak to him as a captive audience, and he would have to listen. Because she took the actions of an initial aggressor, it is our position that there is a duty to retreat caused by the initial aggression, as that is addressed lower in the jury instructions.
The other thing, too, about duty to retreat, it was also his home. So he doesn't have a duty to retreat in his home. So, i.e., he has a right to try and escape the suitcase in which he's confined.
Response, defense.
Judge, I have a different view of the evidence. I think what the evidence has said about the initial in the suitcase is that Mr. Torres was getting into the suitcase and positioning himself into the suitcase when Miss Boone came down. There was like
Even if you buy that story, Ms. Boone still took the step of zipping him up and never unzipped him. So I think that Mr. J is right. She was the initial aggressor. And so all this duty to retreat doesn't apply in the way that Henderson wants it to apply.
after between the two of them. The suitcase was zipped, and it was a consensual deal. It was a consensual thing. She didn't use any threat or use of force at that time to zip him in the suitcase. Furthermore, during the demonstration and when they were demonstrating the suitcase and the zipping ability, I know time has passed, but I hadn't seen anything different. To keep someone in there who didn't want to be in there, if someone didn't want to be in there, it would be almost literally impossible to zip that suitcase because how much force it took to zip that suitcase. So the evidence doesn't support it.
Doesn't support a duty to retreat?
Correct. Because what they're saying, going back even before we had stand your ground, just going back to the castle doctrine, there was never a duty to retreat from your home.
So then if I understand your argument, you are not seeking to have this included then?
I am seeking...
Because if you're saying she had no duty to retreat,
That's correct.
this talks about... Hang on, let me just reread it. Okay, so I think I follow your argument. Okay.
What I'm saying is that it should be no duty to retreat, that Sarah Boone had no duty to retreat. That's what we're requesting. I believe the state's objecting to that and saying that it is a dispute, so they want the next paragraph as to the court.
Well, and this case is unique because the retreat, or what would look like a retreat, i.e. she goes up to bed, in itself is what caused his demise if he was still alive. Right? If this is permitted the way Henderson wants, it would mean that if you're a DV victim, the argument is all going to be all about, who started something, and somebody could come after you, and if they could weasel around the wording as a victim, you're out of luck. This is, I hope he doesn't allow this.
There is nothing that showed at that time, because the state's arguing that she forcefully put him in the suitcase.
Response.
That's a straw man argument. That is not the state's argument. We know what the evidence in this case is. The evidence that she provided was he got into that suitcase by himself and they were playing hide and seek, and he was inside but not completely hidden. The lid was flapping over him. She came over and zipped it shut to whether it's 100% or near 100% shut, and it was all in fun and jest at first, but he did indicate, and we saw it on the video, image IMG_1062, Sarah, I can't breathe, Sarah, I can't breathe. He was being held against his will in that suitcase. That there is no requirement that she initially forced him into it or not. It's no different than two people wrestling and play fighting, and one person has another person in a headlock, and then there comes a point in time where I'm tapping out. Jorge Torres was tapping out, and that's on video, and it's in her testimony. It's uncontroverted. There is sufficient evidence for there to be a dispute as to whether or not she was the initial aggressor. and whether that generates a duty to retreat. And quite frankly, it's undisputed evidence because it's uniquely only her testimony coupled with the video. She restrained him in that suitcase on purpose and intentionally. And if you look at the elements of aggravated assault in our proposed jury instruction, that is exactly what was going on. She intended for him to feel fearful of an inability to breathe, to make it feel like he had made her feel when he had choked her. An aggravated assault is defined as follows: Sarah Boone intentionally and unlawfully threatened, either by word or act, to do violence to George Torres. She would not let him out. She would not release the headlock when he indicated he could not breathe. At the time, Sarah Boone appeared to have the ability to carry out the threat. Well, the video evidence is res ipsa loquitur. He could not get out on his own. He could not get out on his own at 11:12 in the first movie. He could not get out on his own at 11:23 in the second movie. And quite frankly, he couldn't get out at 11:03 during the still photo as well. Element 3. The act of Sarah Boone created in the mind of George Torres a well-founded fear that violence was about to take place. Absolutely. Sarah, I can't breathe. Babe, I can't fucking breathe. Sarah, shh, go fuck yourself. The assault was made with a deadly weapon, element 4. An object not designed to inflict bodily harm may nevertheless be a deadly weapon if it is used or threatened to be used in a manner likely to cause death or great bodily harm. Well, ladies and gentlemen, it did cause death. So that's not a dispute. So it's our position that she was the initial aggressor based on her testimony that we received in court, and that is going to put into play a duty to retreat, and that the parties can then argue about that.
Anything further, Mr. Henderson?
Yes, Judge. I want to clarify this because the initial thing in getting into the suitcase, the act is zipping the suitcase up. That act of zipping the suitcase up was not done forcefully. The testimony was he agreed. He was in the suitcase. He was the one who got into the suitcase to begin with. He agreed. The suitcase was zipped up, and there was no argument at that time. All right. And just by the demonstration that they gave, you could see somebody to get in that suitcase.
Exactly, Mr. Henderson. There was no argument at that time, if you want to believe this crazy story, okay? If you want to believe it. No argument. So she wasn't afraid then, and she took the action to zip him up, and the minute he said no, she needed to listen to that, and she didn't, and she was committing a crime. She committed a crime against him even before she's claiming overt act and threat and all of that. So duty to retreat, I don't think should apply.
Or not get out of it at that time, wanted to be in that suitcase. And there's nothing to dispute what she says, that he agreed, she zipped the suitcase, and they both laughed and thought it was funny. Now, the next thing that the state goes to is an omission. It is not an act. It is an omission at that point in time where she's saying, when they say, oh, he can't breathe, well, she doesn't go, let him out. So they're saying, so they're trying to make that an act when it is not, when she just did not let him out. It's different. And what we're talking about is just the duty to retreat at this time. We're not even talking about the other parts as the thing, but as to the duty to retreat, she's in her home. And at that point in time, when that act took place, she had no duty to retreat.
Here's what the form instruction says. If it is undisputed by the parties that the defendant had no duty to retreat, give the following sentence. Defendant had no duty to retreat before using or threatening to use deadly force. Instruction goes on to read, if the parties dispute whether the defendant had a duty to retreat, give the following paragraph. It sounds like both of y'all, are disputing whether or not there's a duty to retreat.
Yeah.
So I think I have to, based on what the Florida Supreme Court's instruction to me is to give that second paragraph. State, anything further?
No, thank you.
Defense, anything further?
Just note the objection, but I understand the court's ruling.
Okay, all right. So the language in the red line from the defense as to Sarah Boone had no duty to retreat before using deadly force will be removed, and I will add in the state's proposed language, which tracks the form instruction. Is there any objection? Do you want me to read that to you, Mr. Henderson?
No, I'll read it real quick, Judge.
Okay. And I just want to make sure we're all on the same page. That's the state's proposed revisions to the 3.6F on the top of page 2 of 7.
Yes. I'd ask that the court would read it.
Sure. Okay. If Sarah Boone was not committing any crime other than the alleged second-degree murder or manslaughter for... Okay, I will add that. Thank you. For which, so it'll read, if Sarah Boone was not committing any crime other than the alleged second-degree murder or manslaughter or culpable negligence for which the defendant is claiming self-defense or defense of others, and if she was in a place where she had a right to be, then the defendant had no duty to retreat before using deadly force.
There you go. But the poor jury is going to have to sit there and go, okay, let's make sure we understand what this means. And the part that's going to get Sarah is if she was not committing any other crime, which she was, which Mr. J keeps pointing out from the beginning.
On the other hand, 1, if at the time Sarah Boone used deadly force, she was committing an aggravated assault, or if at the time Sarah Boone used deadly force, she was not in a place where she had a right to be, then the defendant had a duty to retreat. The duty to retreat means the defendant had the legal obligation to use every reasonable means to avoid any danger before using deadly force. The law does not require the defendant to retreat if she was placed in imminent danger of death or great bodily harm or imminent danger of the commission of, parentheses, applicable forcible felony, end parentheses, against herself, and it would have increased her own danger to retreat, or if retreat would have been futile. But if the defendant had a duty to retreat, and if she could have safely retreated but did not do so, then her use of deadly force was not justifiable. I do have a question as to the applicable forcible felony portion of that.
I believe they were waiving B. That's for her, for the A and B that we already previously discussed, not for the...
That is correct. So then that sentence would be revised to, the law does not require the defendant to retreat if she was placed in imminent danger of death or great bodily harm, and it would have increased her own danger to retreat.
Yes.
What say you, Mr. Henderson?
Judge, I enter objection as to the instruction, as the state has included to get this instruction an aggravated assault, which is not charged in the information.
State response.
Judge, I'm happy to hop into that one as well.
Okay.
I understand what Martinez versus State says, and I'm sure we've all read the opinion. It's in my motions, and I understand what it holds. What it says all throughout the opinion is there needs to be an independent forcible felony. And then at the very, very end of the opinion, it says there needs to be an independent felony charged. Why I'm asking for a special jury instruction, and I've made that request in writing, is because under the standard jury instruction that we are going through right now, it says, according to Martinez versus State, that the independent forcible felony needs to be charged. The whole purpose of this is you can't engage into a circular logic argument that defeats Ms. Boone's right to self-defense. So it would be preposterous to include in this jury instruction, Ms. Boone did not have a right to use justifiable use of deadly force by committing second-degree murder against the victim. when that's the charged offense. And she, of course, would have the right to use deadly force to defend herself against the victim, and that would be correct. But what we have in this case, and what the state has alerted the court and the defendant to well before trial, was the evidence shows that she committed a separate aggravated assault. She, at the time that she had already zipped him shut in there, and again, just because she releases that quote-unquote chokehold by sitting on the couch, she is exerting that force through distance because she's the one that zipped him shut. So she, in using that force, is the one who did that on purpose to make him feel like he was choking and make him feel like he had made her feel like when she was getting cheated on, and to intentionally confine him in a place so that she could speak to him about her thoughts. As I already outlined, it's the state's position, and the evidence does support that this is an aggravated assault. She intentionally put him in fear of death, and she relished it. She relished it for that 2-minute video. That is prior to when she says, well, now he's sticking his fingers out and I get scared by that action. And by that action, it's George Torres just trying to exert the will to live and to survive and be on this earth. That now that action, if his attempt to escape out of the suitcase that she has left him zipped up in, is this independent threat of great bodily harm and death to her. She testifies if he gets out, it's her belief that he will beat her up, kill her, disfigure her, so on and so forth. And her testimony at trial, I believe she said was, he said that I will end you. So what we have here is they, by their own admissions, through the testimony that she provided, that there is a separate and distinct independent forcible felony from what ends up being the second-degree murder. What ends up now being the second-degree murder is at this point in time when she says, well, he's trying to get out. I'm afraid if he gets out, I'm going to get disfigured or killed. And so that is why Ms. Boone makes the decision, and I'm not even going down the aggravated battery path, but she batters him with a bat on the hands and batters him, pokes him while he's in the suitcase, and basically beats him into submission so that he stops trying to escape. That's what the testimony was. And then she makes the decision to now leave him and go upstairs and go to sleep without having relieved him from the force that she exerted earlier committing aggravated assault.
He's correct. I think everybody listening understands and agrees. Yeah, he's right. I mean, and that's even taking into account that if you believe this cockamamie story of hide and seek in the first place, one of the things that she said on the stand to try and, cover the holes in her story about why she would leave the suitcase open and go up and go to sleep. One of the things she said on the stand was she beat him with the bat and it stopped. Him getting out, trying to get out, him threatening. The threat stopped at that point. So some of this argument is pointless because at that point, when the threat stopped, and we all know the threat never happened. I get that. Well, even by her own story, the threat stopped there. So she had no more excuse for self-defense subsequent to that.
So like the example I gave you earlier, this is absolutely no different than me pointing a gun at you, Judge, and putting you in fear of your life that I'm going to shoot you and a projectile is going to enter your body and kill you or give you great bodily harm. And you, in turn, after having been placed in fear by me pointing a gun at you, you begin to defend yourself and exert your right to live on this earth by pulling your own firearm. And now, do I, as the initial aggressor, the initial person who committed the forcible felony of aggravated assault on you, under the law, I don't have the right now to defend myself against you. I need to retreat. I need to make it clear, sorry man, my bad, drop my gun and walk away. That is what is the law. 776041 is a very short and very, very simple statute. And it has not changed since 2014. This has been the law. This was the law at the time of this offense in 2020. 776041 provides, the justification described in the preceding sections of this chapter is not available to a person who, 1, is attempting to commit, committing, or escaping the commission of a forcible felony. So taking away the firearm example, it's a chokehold. His cause of death, according to the medical examiner, was asphyxiation by position and environmental suffocation, caused by her not releasing a chokehold on him when he indicated, babe, I can't breathe, Sarah, help. That is an independent forcible felony, separate and distinct now from what she says is the victim, like you, pulling a gun to defend yourself from me pulling a gun on you. Now, the threatened use of force that the victim is exerting is sticking his hands out and saying, I'm going to end you. That is the distinct break between the aggravated assault and now her continuing to use this unlawful force, which she's not entitled to do because she started it. She was the initial aggressor in committing this aggravated assault. And she ends up just leaving him to die and never releasing the chokehold.
And the unlawful threat is what's on the video in your realm.
Yes.
Okay.
And any facts that support that should cause this jury instruction to be given. The absolute only hang-up about whether or not this jury instruction should be given is because Martinez slightly overstates what is necessary to prevent this circular logic, which is not going to occur in this case. There is not going to be any arguments by the state that she does not have the right to defend herself if she is in imminent fear or death of great bodily harm by the victim. She testified that him sticking his hands out of the suitcase and saying, I'm going to end you, put her in fear of imminent death and great bodily harm. And in turn, what she did was
Actually, her testimony was not that. Her testimony was, she talked in terms of like, I guess this is what he said. And she didn't say, he said, I'm going to end you. She said, well, he was going to end me. She couldn't even come up with a quote to give him. And then, I don't know, 20 minutes later, 10 minutes later in her testimony, she claimed he said something, uttered a threat, and it was a completely different thing.
decided to not let him out. And he ended up dying. And that is second-degree murder. That is separate than what preceded that. What preceded that was her not letting him out when you can see him pushing up on the suitcase in the video, begging to get let out, and she doesn't because she is doing this out of anger, hatred, ill will, and spite to teach him a lesson and put him in fear of death or great bodily harm. That's an aggravated assault. I would absolutely charge her with aggravated assault and aggravated battery, separate independent forcible felonies, if I could. But I did not learn this information until after the statute of limitations had passed. That is through no fault of the states. So we absolutely would, if we could. And we...
Wow. Because of a technicality and because Sarah Boone lied her face off for so long, right? Because she hid time and hid everything. So that explains to me why they didn't. And I didn't even think of that reason. Where I am, an indictable, there's no statute of limitation on an indictable offense. There's only statute of limitation on what we call summary conviction offenses. So very interesting. But the evidence does show all of these crimes that he is talking about.
We are not going to make the argument and defeat her defense of second-degree murder by saying, well, you can't defend yourself with I understand what they're getting at in Martinez. That's not this case, though. It's broken down into those parts.
Can I have the citation for Martinez? Because unless I missed it in your motions, I didn't see Martinez cited in the motions.
I'm sorry.
And forgive me if I
No, it's
missed it.
been in previous motions.
Because you cited a Cologne with regard to the Miranda issue.
No, I'm referring to, there's a pleading entitled State's Request for Forcible Felony Instruction and Request for Initial Aggressor Instruction, which we've kind of hopped into now since aggravated assault is being mentioned in this paragraph. In paragraph...
Oh, there it is. I apologize.
Yeah, paragraphs 12 through 31 are the legal analysis, and Martinez is cited in there at paragraph 19 at 981 Southern 2nd 449 Florida 2008. And more importantly, what Martinez doesn't say is that there's like some requirement that the verdicts would be interlocking. Like there's no requirement that second-degree murder be count 1 and aggravated assault be count 2, and then if they return a not guilty verdict on aggravated assault, then there has to be a not guilty verdict on the second-degree murder. That's not the case, because there's so many different prongs to the self-defense instructions. So it's not required to be charged for some reason of an interlocking verdict. And the whole spirit of that opinion is that it is to make sure that we do not defeat her self-defense argument that she's entitled to make about why she committed second-degree murder. All we're saying is you're not entitled to defend yourself in that manner if you committed an aggravated assault to start this.
I think this is a good example, this back and forth here, and what the case law for that case, what it actually says, and that this charge has to be part of the whole thing. I think this is a good example of the difference between there's the letter of the law and there's the essence of the law. And sometimes the letter of the law won't make sense in a case, or it doesn't apply. And so you go back and look at, okay, what was intended by this law? What is the principle behind this? And this is why, law isn't black and white. It is so nuanced. There are so many shades of gray, so many exceptions and distinctions. And I think this is an interesting example of just that.
And that's what the facts show. It's a little complicated, and there's another special jury instruction related to this force by distance. It's like tying somebody to some train tracks and walking away. I mean, are you still choking the person? No, but are they restrained in a manner that if a train comes, they will die? Yes. So the special circumstances of this case and the facts are going to warrant, in the state's estimation, the forcible felony paragraph, and then that language being placed into this initial paragraph that we're talking about.
Just reading Martinez. Give me a moment.
Yes, sir.
I like the tying to the train tracks analogy.
And just for the
That's
record,
good.
the 3 prongs for a special jury instruction, which I cited in a couple of my other pleadings. A special jury instruction is warranted when A, the special instruction is supported by the evidence, which is the case. It's in fact undisputed since there was only one person there. B, the standard instruction did not adequately cover the legal theory it is meant to. That is also true. And C, the special instruction was a correct statement of the law and not misleading or confusing. That is also the case. Stevens, Stephen's versus State, 787 Southern 2nd, 747. Am I mistaken by 657? I imagine.
I think it's 755 is the pinpoint.
Yep, 2001.
Yeah, I reviewed that already. Thank you. Response.
Response is clear, Judge. They They're trying to make exceptions for the law. That doesn't work here. Simply this, what the requirement is under Martinez to get the aggressor is this. It's only applicable and only in cases where the defendant was charged with either an independent forcible felony, that's Martinez, or B, felony murder. That's a different case. In Martinez, they have not charged an independent forcible felony. So it doesn't apply. It tells us right there. That's the standard jury instruction.
Oh, this is interesting. You know, Henderson is not actually wrong here. So he's arguing for the letter of the law. Mr. J is arguing for the essence of the law. Very interesting. Judge Kranick is so, by the book. I'm very interested in seeing how it's going to go.
For him to come back here and say, well, really, Judge, they overstated Martinez. Martinez is still good law. It has not been changed. That's the rule. That's the requirement.
But this is relying. Martinez's opinion states, indeed, consistent with this case law in 2006, we approved an amendment to the self-defense jury instruction to specifically provide that the forcible felony instruction should be given, quote, only if the defendant is charged with more than one forcible felony. That doesn't seem to be what the new instruction says, unless I'm missing something.
I'm sorry, can you repeat that?
Sure. The sentence says, indeed, consistent with this case law, in 2006, we approved an amendment to the self-defense jury instruction to specifically provide that the forcible felony instruction should be given, quote, only if the defendant is charged with more than one forcible felony. And unless I'm missing something, a 3.6F instruction doesn't say that now. The form instruction.
Judge, when it comes to the aggressor in the standard jury instructions, when it comes to aggressor, and they're talking about under 776.041 sub 1, it's to only be given if and only in cases where the defendant is charged with either an independent forcible felony. You cannot give this instruction unless there's an independent forcible felony that Ms. Boone has been charged with, and there just isn't one.
But where does it say that in the form instruction?
Judge?
Yes.
It's page 14 of 28. Aggressor, 776.041, 1, Florida statute, give if applicable and only in cases where the defendant is charged with either A, an independent forcible felony, Martinez versus State, 981-449, Florida 2008.
Hang on.
For the felony. And we're acknowledging that. But when you look at the case and what it is stating is the purpose of that is there has to be in the evidence an independent forcible felony. And that is what occurred in this case. She committed an aggravated assault. After that, the defendant is saying the victim placed her in fear of imminent harm or death by trying to escape her aggravated assault, by sticking his fingers out, and by saying, as he's trying to escape, I'm going to end you.
But isn't that in the giving the aggressor definition? I mean, is that? But unless I missed something, that's not what we're talking about right now.
I agree, but I think it cohabitates together.
Okay.
And it's our position, we absolutely would charge her. And it's a legal technicality in part of this standard instruction that we can't because of the statute of limitations. We all know, all of us here together as attorneys, know that those facts, if believed by the jury, support that she violated Chapter 776.041, 1. She should not be able to get away with murder because of a statute of limitations technicality that was through no fault of the state's own. The purpose and spirit of Martinez is to make sure that we're not up there arguing, ladies and gentlemen of the jury, she had no right to defend herself from an imminent threat of harm by killing somebody. That's not what we're going to say. We understand that. What we are going to say is, ladies and gentlemen of the jury, she had no right to leave him in that suitcase out of fear of great bodily harm or imminent death because she committed an aggravated assault to put him in that predicament. That's the evidence in the case. That's the arguments that's going to be made. That's why we're making a special instruction request based on the unique facts and circumstances of this particular case.
Give me a second.
Yes, sir.
Aaron saying charged or not, the evidence and Sarah's own testimony shows that she was the primary aggressor. Yes, everybody's clear about that. The issue here is about the law and the jury instructions and whether or not she had a duty to retreat, and having the duty to retreat or not makes a difference in how the jury is instructed to apply this to the issues. So Henderson is arguing the letter of the law. Jay is arguing the spirit or the essence of the law. So I think no matter what Kranick decides, somebody could have a legitimate argument with it. So then if it came to an appeal based on that, the question would be, did that, if a higher court says, yeah, that was an error in the instruction, then they're going to need to look at, whether or not that would have changed the ultimate outcome. So I hope that answered that.
Language in the instruction in pertinent part says he or she was committing an act, insert the defendant's criminal activity that the defendant but the criminal activity cannot be the charged crimes for which the defendant is claiming self-defense or the defense of others. The charged crime is second-degree murder. So I'm struggling with understanding as the other crime because I'm not hearing any argument as to the applicability of aggravated assault.
Judge, and I didn't make any argument about aggravated assault applying because they can't get over the first hurdle. The first hurdle is it has to be charged. It's not charged. That's what the case law says. I mean, this is pretty clear to me unless I'm looking at it wrong when it says this is not to be given if there isn't an independent forcible felony charged.
Any other response, State?
Just said it defeats the purpose of the statute and is manifestly unjust when it is a legal technicality of no import. There is no interlocking verdict required. If we were able to charge aggravated assault, there's no requirement that they both be found guilty. They could go ahead and hear this instruction and find her not guilty of aggravated assault and still convict her of second-degree murder because of all the plethora of permutations we have in this instruction.
But in Martinez, the underlying charge was attempted murder and aggravated battery, both of which were charged, and we don't have that here.
But it's still going to the one act in those facts. We are talking about separate, clearly distinct facts here that support there's an aggravated assault that separately gets committed first, and then in response to the victim responding to that aggravated assault, she leaves him in the chokehold to die because if she lets him out, it's her belief she's going to face death or great bodily harm because she committed a forcible felony against him. This is purely a legal technicality. The entire opinion on Martinez, until the very last paragraph, uses this language.
No, Sarah's not going to walk on a technicality. Jury's not that dumb.
They use language like, the underlying facts of the present case demonstrate why it would be illogical to conclude that section 776041, paren 1, applies where there is no independent forcible felony. It doesn't say where there is no independent forcible felony charged. It goes on and uses that same language all throughout the opinion, and then in the very last paragraph in the conclusion, it changes to, in conclusion, we hold that it is error for a trial court to read the forcible felony instruction to the jury where the defendant is not charged with an independent forcible felony. But
here's an example of how important the words are. It's one word. In the entire case law, one word. And this is a big thing now. This is a big discussion now because of one word.
there is an independent forcible felony in the facts. There is a statute that says that Ms. Boone should not be able to avoid the girth of this jury instruction. She violated, according to the facts that she gave us, she violated 776041 paren 1. She was committing an independent forcible felony and therefore should not be able to get away with this instruction not being given because of the technicality that the state can't charge a case or can't charge a count that is not required to be interlocked by verdict. Thank you.
Okay.
I think Mr. J is frustrated. It's so obvious in his mind that he can't see why other people can't see this. So I'm feeling for him.
Footnote 4 provides, explanation in the Martinez opinion as to certain circumstances and whether or not in that hypothetical that the Supreme Court gave, whether the robbery is a separate and independent forcible felony and the forcible felony instruction is applicable. But the conclusion seems to state that it has to be charged, that it is an error for the trial court to read the forcible felony instruction to the jury where the defendant is not charged with the independent forcible felony. Anything else, Mr. J?
No, sir.
Then how do we want to accomplish this? Because I don't know how I can read the proposed language by the state, and there's a disagreement as to whether there's a duty to retreat. It's not undisputed. It is, in fact, disputed.
Well, their complaint is in the sentence, on the other hand, if at the time Sarah Boone used deadly force, she was, then I just think we strike through committing an aggravated assault. We go to, if at the time Sarah Boone used the deadly force. Okay.
Lizzie's saying, I didn't think this is a big deal. Negotiating is normal. So this process they're going through is normal.
And unless you just want to go.
But it also is a big deal because it's going to affect what the jury can and can't do and how they consider things.
2. On the other hand, if at the time defendant used deadly force, she was not in a place where she had a right to be, then the defendant had an obligation to, then the defendant had a duty to retreat. Just excise 1 completely. I don't know what else to do.
Well, she has a right to be there.
Right.
Sammy is asking why wasn't she charged with the aggravated assault also? There were other things she could have been charged with, but the state didn't know that. And unless the state had evidence of that, there's nothing they can do about it. The evidence of that came later, but it was too late. The statute of limitations had passed, so they couldn't charge her.
Under the Castle Doctrine and the case law.
Okay, then I think we go with the first paragraph and then we just deal with the initial aggressor at the end, which is kind of the exception to that. So
Okay, so then Sarah Boone had no duty to retreat before using deadly force.
Yes.
Okay, is that acceptable to the defense?
Yes.
I think it puts us back in the position where we started at anyway.
Yes.
Okay, all right.
I just object for the record in case some assistant attorney general wants to potentially cross appeal something.
Objection noted. It looks like the next parts of the form instruction, if the defendant was in a dwelling, was excised, the give A, B, or C was excised. Are you on board with that state?
Yes, sir.
Then the next paragraph, a person is not justified in using force to resist an arrest. Clearly, that's not applicable. I don't think that's at odds. However, if an officer used excessive, I also don't believe that's applicable based on the facts. We then proceed to the give in all cases language. Any objection to this language state?
Just kidding.
Sure. It's the bottom of page 2 of the defendant's 3.6F red line.
Somebody in the chat is saying she's going to get away with everything. No, she isn't. I mean, I don't have a crystal ball for what the jury is going to think. It's going to come down to the jury. I don't think she's getting away with everything.
I'm just finding where it's in
On the form instruction, it's the bottom of page 3 of 7. Give in all cases, right after Jackson v. State.
Yeah, just the agreed upon strike terms of or threatened use. So it's just being deciding whether Sarah Boone was justified in the use of deadly force. You must consider the circumstances at the time.
Any objection?
No objection to that, Judge.
We'll excise the threatened use, so it will all read use of deadly force in that paragraph. All right. Now we have a proposed instruction, I believe, from the defense regarding battered spouse.
We table the battered spouse proposed instruction since both parties have that.
Sure. Moving now to the presumption of fear, that's been struck out by both parties and agreed to. Moving to the exceptions of presumption of fear, that's been struck out by both parties and not necessary. That takes us to a person who unlawfully by force enters or attempts to enter, that's not applicable. Definition of dwelling is not applicable. Residence and vehicle are not applicable. That takes us now to the aggressor language.
No additional arguments as to why the facts show she was the initial aggressor, and thankfully for the state, there's no requirement under this provision that there be an independent forcible felon.
Okay. Looks like we have a disagreement between the parties as to the application of the aggressor instruction. It's struck out on the defense's side and not in the state side. What say you, Mr. Henderson?
Give me 1 second.
Sure.
Please.
Yes, sir.
Sub 2.
Yes, sir.
Okay. If I could have one more.
Yes, sir.
my argument would be that the only evidence, well, the evidence from Sarah Boone stated that she did not do anything forcefully wise.
Did you hear him catch himself? Judge, the only evidence, well, the evidence from Sarah Boone.
Until after Mr. Torres had made verbal threats and was coming out of the suitcase. So that's my objection is based on that. No other legal argument.
Any other argument? State.
Just judge, it's play wrestling and not releasing the chokehold when your buddy taps out.
And I mean, isn't there evidence as to what Ms. Boone had told the experts, which seems to be at odds with that issue, and it's really a factual issue and a determination for the jury to make that determination on what the real facts are?
I can't disagree with that.
Okay. Then with regard to the proposed language as the 776.041 sub 2 instruction, however, the use of deadly force is not justified if you find that Sarah Boone was attempting to committing, or escaping after the commission of aggravated assault. An aggravated assault is defined.
No.
No?
That's the friend one.
Am I on the wrong section? I apologize. I am at the wrong section. Forgive me. So it is the, however,
With my strike throughs, it's however the use of deadly force
is not justified if you find that Sarah Boone used force to initially provoke the threatened use of force against herself unless, 1, the threat of force asserted towards the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger other than using deadly force on George, that's spelled incorrectly, Torres, or 2, in good faith, Sarah Boone withdrew from physical contact with George Torres as clearly indicated to George Torres that she wanted to withdraw and stop the use of deadly force, but George Torres continued or resumed threatened use of force.
Yes, sir.
What's your, just for clarification purposes, anything else as to that instruction, defense?
Just one thing I need to put on the record, Judge.
Yes, sir.
The force at that time, as testified to, was the poking of the bat on the outside of the suitcase. There was one strike when the hand was outside. These were bruises. I think there was something that came to the injury to the head area, though. The injury to the head could be serious, but in this instruction, it's talking about deadly force. And none of those, as to the testimony from the medical examiner, none of those injuries caused the death.
But the continued restraint on him that she did not undo is the force that we're talking about. It's just like in the cases that I cited in my special state's request for special jury instruction regarding withdrawing from physical contact. Batteries don't need to be skin to skin. You can commit a battery on somebody while driving your car and striking their car. A false imprisonment does not mean you have to choke somebody. You can falsely imprison somebody by barricading them into a room with a grocery cart. She unlawfully exerted that force and did not withdraw from using that force when her wrestling partner, so to speak, tapped out.
Okay. I'm going to include the instruction for now. The next paragraph reads, if you find that Sarah Boone, who, because of prior threats or difficulties,
No objection from the state.
all right, that'll be included. The next paragraph, if you find that at the time of the alleged aggravated assault and or criminal mischief,
Yeah, there just needs to be secondary murder, manslaughter, or culpable negligence, and we don't object if there were specific acts put into evidence.
any objection to changing the beginning of that sentence, defense, if you find that at the time of the alleged murder in the second degree, manslaughter, culpable negligence, Sarah Boone knew that George Torres had committed an act?
Yes.
Okay, thank you.
And we requested the strike through at the end or threatened to use.
Agreed.
Give me a moment. So that sentence would now, or that section would now read, if you find that at the time of the alleged second-degree murder, manslaughter, or culpable negligence, Sarah Boone knew that George Torres Jr. had committed an act or acts of violence, you may consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use deadly force. Acceptable?
Yes, sir. I just don't know that we use Junior after his name anywhere else.
Give me a moment. Yeah, Junior's not used anywhere else, so I'll excise that. Is that acceptable to you, Mr. Henderson?
Yes, Your Honor.
All right, moving to the next line. If you consider that George Torres, removing Junior, had a reputation for being a violent and dangerous person, I don't know, did we hear evidence of reputation?
The state's position is going to be there's no reputation evidence. Ms. Boone offered an opinion, but as everybody knows, reputation evidence has to come from a broad enough aspect of the community, whether it be a church or a neighborhood or perhaps even a large family. But
Defense?
I'm rethinking that, Judge.
No worries. Take your time.
Oops, defense missed some.
Generally, and reputation evidence, generally, it has to be something that is known based on a community standard, all right, and that was the community. I know the only thing that I can relate to is the fact that individually, she experienced certain things that could build that reputation, but that's unheard. I think there's evidence, though, from people, at least that they knew about it or were told about it. Most of that was stopped. But I could go to at least the one situation on a text message that was introduced earlier today that talked about him beating his former wife or ex-wife.
How is that reputation? It sounds like that's a specific instance based on that text message.
And it's also gossip based on, once again, Sarah Boone's narrative. It's not reputation.
Correct. I agree.
Okay, so in agreeing, we're going to excise the reputation section, correct? Okay, thank you. The court will excise that.
the state agrees to the physical abilities that's mandatory in the case.
What about the one that precedes that? If you find that George Torres had a reputation, well, also that reputation would be removed as well, correct, Mr. Henderson? If you find that George Torres Jr. had a reputation for being a violent and dangerous person, you may consider this fact in determining whether he was the initial aggressor.
That's correct.
Okay, so that'll be excised as well. State has no objection to the physical ability section. I'll just remove the word junior after Torres. Any other questions with regard to the 3.6F instruction?
Your Honor, state doesn't object to what we have produced as the final product. I'm impressed we did it so quickly. We just note our objection for the record to preserve a challenge to Martinez's opinion.
Understood. Do the parties, well, let me ask this question. Mr. Henderson, anything else we need to address with regard to the 3.6F instruction?
No, sir, I'd just like to preserve the objections that I made during this conference.
Objections preserved. Do the parties wish the court to reread the 3.6F instruction that we just went through?
So the issue of the reputation evidence, the instruction that the defense wanted in there, and the fact that reputation evidence was just based on Sarah Boone, well, that's not reputation evidence. That's just Sarah Boone. The judge, the decision was that, yeah, they're not putting that in there. So it's not don't worry about it. The judge took care of it. He excised it.
To make sure we're all on the same page.
Yes, sir.
Can we do it at a time where it
Is in final form?
Yes.
Yeah, absolutely. Okay.
Perhaps a written copy that we can take during snack time.
Sure, absolutely. All right. Where does that take us now? Does that take us to the 3.6G instruction?
I believe so.
Okay, give me a moment. I have the form instruction from the Supreme Court, and I have the defense's proposed revisions. Just move everything around here. Give me a second. Okay. Discuss the or threatened use should be removed. Is that correct?
That's correct.
All right. As to the first sentence, it is a defense to the crimes of second-degree murder and culpable negligence if the actions of Sarah Boone constituted the justifiable use of threatened use, as we're removing justifiable use of non-deadly force. Would be removing threatening, and we would also be including manslaughter, correct?
That's correct.
State?
Yes, sir. It is a defense to the crime of second-degree murder, manslaughter, in Oxford, or culpable negligence if the actions of Sarah Boone constituted the justifiable use of non-deadly force.
I, too, am a big fan of the Oxford comma. So the defense would, or the instruction would now read, it is a defense to the crimes of second-degree murder, manslaughter, and culpable negligence if the actions of Sarah Boone constituted the justifiable use of non-deadly force. Acceptable state?
Yes, sir.
Acceptable defense?
Yes, Your Honor.
Definition of non-deadly force is not at issue. Next paragraph. Sarah Boone does not have the burden of proving that she was justified in using non-deadly force. Instead, for you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah Boone was not justified in using non-deadly force. Acceptable state?
Yes, sir.
Defense?
Yes, Your Honor.
The law on justifiable use of non-deadly force is as follows. Sarah Boone was justified in using non-deadly force against George Torres, excising Jr., and had no duty to retreat if she reasonably believed that such conduct was necessary to defend herself against A, George Torres, excising Jr., imminent use of unlawful force. Is that instruction acceptable?
Yes, sir. I don't know if you mean to include the A if we're not using the B. I would just suggest you make one sentence.
Any objection?
No objection.
Okay. Any other issues with the instruction as read so far? State.
No, sir. Thank you.
Defense.
None, Your Honor.
Okay. Looks like there are several agreements with the balance of this instruction as to the defense of property is not applicable, the 776.0134 dwelling and residence and vehicle, and force with regard to law enforcement, all of which is not applicable in the instant case. That takes us to the give in all cases. We would be removing the threatened use of non-deadly force in that section. Any other changes is to the give in all cases section.
Not from the state. Thank you.
Defense.
None, Judge. No objection.
Okay. Let's table the proposed instruction on the battered spouse for the moment.
And the state will be making its request for the forcible felony instruction.
Under Martinez.
Yes, and we understand the court's ruling, and we're sending a strongly worded disagreement to the court's Supreme Court.
Received and understood, but based on what the court said earlier as to the conclusion in the Martinez section, I'm disinclined to add your proposed instruction.
I understand why.
That takes us now to the 776.0412 section. Looks like we have a little bit of a disagreement here. Is it the same arguments that we received in the 3.6F instruction?
It's the same fact.
Any other additional arguments, sir?
No, Your Honor.
All right. For the reasons previously identified, the court will accept the state's proposed portion as to the 776.0412 instruction. Then it takes us to the prior threats.
Same requests and objections as in 3.6F from the state, sir. For the end of the instruction.
I agree that it should track with the,
Forgive me. Other than reputation, what were the other issues?
Prior threats should come in.
Mm-hmm.
Specific acts should come in.
Okay, thank you. Reputation should be excised.
The 2 paragraphs of reputation excised, and then physical abilities gets read in all cases.
Agreed?
correct?
Okay.
Agree.
All right. And then we'll remove the threaten language in there, correct?
That's correct.
Give me a moment. Okay. Any other questions with regard to the 3.6G instruction state?
No, thank you, sir.
Defense?
None, Your Honor.
Okay. I believe then, just double check my notes. I believe then that addresses those issues based on what we did not discuss this morning in the charging conference. And I think that now takes us to the state's requests and the defense's request for special instructions.
Can we do the battered spouse one first, since we have conflicting requests?
Yes. Specifically, we're making reference to the state's request for special jury instruction regarding battered spouse syndrome filed, I believe it's not dated, but I think it was either the 23rd or the 24th that you filed these, Mr. J, and the court record will speak for itself as to when they were filed. Okay. Courts reviewed that motion and reviewed the proposed instruction by the defense. State, let me hear from you first.
With their instruction, I think the problem with it is that it kind of blurs the subjectivity component versus the objective, reasonable person standard. So if we make this change to their instruction, then I'm actually okay with it. What I would suggest that change be is in.
I'm laughing because here we go. So remember earlier this thing about subjective versus objective kept coming up? Well, here it comes again in the jury instructions.
In the second paragraph, if you find the evidence that Sarah Boone suffers from battered spouse syndrome credible, you may consider this evidence to assist you in determining whether a person in Sarah Boone's circumstances would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by the victim, No Jr. I don't know if it's necessary with the date. That makes it clear, because that's what the case law says. The case law makes it very clear it's about the objective component.
I agree with you.
And then I would just ask for my last sentence, which is, like other witnesses, you may believe or disbelieve all or any part of the testimony regarding battered spouse syndrome.
What say the defense? And if necessary, I can read.
Yes, could you do that?
So it looks like there's no, first of all, just so the record's very clear, Stevens v. State identifies the special instruction circumstances, special instruction.
So chat is asking a number of questions. And one is, she's charged with second-degree murder. Did they add charges? Somebody's asking, well, can the jury just find her guilty of first? So I'm going to address some of this. So the jury cannot find a defendant guilty of a higher crime from which they were charged. So you can't be charged with second degree and have the jury turn around and say, yeah, we think it's first. that can't happen. You can be charged, or sorry, you can be convicted of lesser included offenses, right? So here, for example, an assault, you could be charged with an assault, but a lesser included offense is attempted assault, and the penalties are the same, for example. So you can go down, you can't go up. So it may, to somebody just sort of half paying attention or not understanding, it may seem like, oh, what? They added a bunch of charges. No, they didn't. These are the things the jury can find her guilty of. And the highest charge on the list that they're allowed to find her guilty of is the second degree. Did that answer that bunch of questions in the chat?
Instruction is supported by the evidence in this case? Yes, absolutely. The standard instruction did not adequately cover the legal theory it is meant to. There is no standard instruction on battered spouse over and above what's included in the self-defense instruction. The special instruction was a correct statement of law and not misleading or confusing. We're addressing that third prong of Stevens at this time. The proposed instruction would read, you have heard evidence that Sarah Boone suffers from battered spouse syndrome. If you find the evidence that Sarah Boone suffers from battered spouse syndrome credible, you may consider this evidence to assist you in determining whether a person in Sarah Boone's circumstances would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by George Torres. It would then go on to read, like other witnesses, you may believe or disbelieve all or any part of the testimony regarding battered spouse syndrome.
Agreeable.
Okay. Appreciate y'all working together on that. Give me a moment to finalize this. As such, the third prong of Stevens has been made, and the court will give the special instruction as identified on the record. Now, the only question I also have is, do we want this as its own instruction, or do we want this included where it currently is in the 3.6F and 3.6G instruction state?
I would suggest it be 3.65, right after the two instructions about use of force.
I agree with that.
Okay. Do we want to label it or just have it as special instruction and then read it? Do we want to have the title special instruction on battered spouse? I welcome.
I'm fine with just saying battered spouse syndrome.
That's fine.
Okay, so it'll be special instruction on battered spouse syndrome. Is that acceptable?
Yes, sir.
Is that acceptable?
Yes, sir.
All right, thank you. All right. And that will follow after the 3.6G instruction, correct?
Yes, sir.
Acceptable,
Yes.
Mr. Henderson?
Yes, sir.
All right, that takes care of that.
All that should be left. Oh, go ahead.
Yes, I'm sorry, sir.
I'm sorry. I think we might be required to read it both times after each one.
I have no problem with adding a paragraph into it that says this applies to both the justifiable use of deadly force and non-deadly force.
That's fixed.
Okay.
I'm so glad it's Henderson doing this. He knows the law, the case law, and the mechanics and everything better than Owens, it seems. I can't say that's a fact. It seems. And he is more respectful and not pedantic and, right?
Where, gentlemen, do you want that?
After the big paragraph that ends with George Torres and before like any other witness.
Sure. Okay, so let's go over that language one more time so that we're all on the same page. Mr. J, what is it that you propose?
To put between the paragraph that ends with Jorge Torres and before the paragraph of like other witnesses or whatever I said, you can consider this testimony and evidence in the applicability or the use of whatever word people agree on of both deadly force and non-deadly force instructions, something to that effect. that's too convoluted, I'm fine with it just being repeated.
I tell you what, I'd rather just repeat it.
I think so.
That gets way complicated.
Yes.
I'd rather just repeat it under 3.6F and 3.6G.
Agreed.
Okay. Does that work with you, Mr. Henderson?
Yes, sir.
All right, thank you, sir. All right. Okay. Moving now to the state's request for special instruction regarding withdrawing from physical contact, filed October 23, 2024. Court has reviewed it. I guess the first question is, is there proposed language?
Trying to see if I'd actually put that in there.
I don't know that I see it, Mr. J.
Oh, paragraph 15. Physical contact includes any restraint on George Torres, apostrophe, movement.
And this would be after the initial aggressor portion in the 3.6F and 3.6G, correct?
Yes, sir.
Okay, what say you, Mr. Henderson?
If I could have one.
Yes, of course.
Aggressor, it should come in not there, but shouldn't it come in because that's not there anymore? Initially provoked.
Yeah, in the 3.6F instruction, references to initial aggressor have been removed.
Yes. So now is the state asking for it to come in as the initially provoked?
Unless I missed something.
My understanding was that it was the two paragraphs about aggressor are coming in. What's not coming in is the Martinez forcible felony. The facts of the case.
Right, but the language, you said at the conclusion of the paragraphs regarding initial aggressor, the words initial aggressor don't appear in the 3.6F. It's only after that. However, the use of deadly force is not justified if you find Sarah Boone used force to initially provoke the threatened use of force against herself unless, and then it's paragraphs 1 and 2. Is that where you're asking it to be?
Hold on, let me pull through it.
Sure.
You guys are here. So in 3.6F,
Mm-hmm.
it should be, however, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke
Correct.
the
That's what I
threatened
have.
use of force against herself unless, parens 1 and 2.
Correct.
And then after 2, as an explanation for what is listed in paren 2 as from physical contact, just that elaboration of what we're talking about.
I got it.
Because
Okay.
the unique circumstances of this case, the remote force.
Okay, I got it. I just want to make sure we're all on the same page as to where. What say you as to the proposed language of physical contact includes any restraint on George Torres's movement as that portion in 3.6F and in 3.6G?
No objection.
Okay, all right. So court's going to grant the state's request for special instruction regarding withdrawing from physical contact. And the language of physical contact includes any restraint on George Torres's movement will be included after the however the use of deadly force language after paragraph 2 in the 3.6F instruction. And in the 3.6G instruction, it will be at the end after the physical abilities section. Also, it's George is spelled incorrectly. That will be remedied.
I thought the two paragraphs about aggressor were being mirrored in 3.6G. It shouldn't go after physical abilities. It should go after.
Oh, I'm sorry. You're correct. I apologize.
No problem.
Okay, got it. That takes us now to the state's request for special jury instructions on causation, filed October 23, 2024. I have reviewed it and the proposed instruction on paragraph 3 therein.
Judge, the reason we're bringing this up is just during the cross-examination of Dr. Z, or Zadovich, we poked the bear a little bit about his cardiovascular condition. My memory of the testimony was that she's emphatic that that was not the cause of his death. But because of that, and because of now the request of culpable negligence at misdemeanor for a lesser, I feel it might be warranted to give this explanation of causation in the second-degree murder and manslaughter instructions.
Defense, what say you?
Yeah, there's the but-for concept here,
Judge.
too.
I would object. I believe that just the instruction, the proposed instruction that I have it as one but for the defendant's criminal act, which we have a standard jury instruction that said the death was caused by the criminal act of the defendant, and that's what they're required to prove. This language, to me, would lessen that requirement by saying but for the defendant's criminal act. Then the second part, when it goes up to George Torres' death, was not beyond the scope of any fair assessment of the danger created by the defendant's criminal act. I think that's covered, Judge, in the fact that the state does not have to prove that Ms. Boone had the intent to kill George Torres. So that makes it confusing to me when the standard instruction basically simplifies it, in my mind,
I actually think Henderson might be right here.
and it keeps them right where they're supposed to be with that instruction. They don't have to prove that she had the intent. Then, as to the third part,
I'll withdraw my request for that.
Okay.
If heart disease gets brought up in closing, we'll do it.
All right, fine. So withdrawn. Court takes no action on the state's request for special jury instruction on causation. That leaves us now with state's request for forcible felony instruction and request for initial aggressor instruction. That's already been addressed, has it not?
I was just treating it as a special jury instruction for my argument.
Understood. All right, are there any other instructions sought by the state at this time?
I believe we have concluded this exercise.
Defense.
no other ones.
All right, here's what I'm going to do. I'm going to take all this upstairs. I'm going to re-review it. I'm going to merge it all into one document, and I will send it to all the parties. Let's plan on being back here at 1:30, and we'll address any other concerns with the jury instructions at that point in time. State, anything else we need to address?
125.
Let's make it 1:20.
All right, thank you.
Defense.
Nothing else.
All right, we'll see y'all at 1:20. Thank you.
Okay, I'm just going to address chat for a couple of minutes or less before we sign off and take a break. So I'm seeing people getting nervous. I'm surprised how many people are actually still here watching this part of things. I thought a lot of people would be sleeping through this. So I am surprised to see so many people on it. So some people in the chat are getting concerned over all of this. Yes, it's important. I'm not seeing anything that makes me think, oh no, oh my gosh. I'm not seeing anything that makes me worried. So for whatever that's worth to you. Yeah, some people are interested in the nuts and bolts that they're seeing, the behind the scenes. And I noticed someone in the chat had said earlier, this is kind of interesting to see this stuff in the background. Yeah, the stuff you see on TV, all the drama, that's not really how it is. And when you watch a trial that's upsetting and you're hyped up and upset, sit a couple hours through this kind of thing, and your brain has to be focused on these nuts and bolts. It does sort of balance things out a little bit. So K Love is asking, why are they excising jar? I'm not sure what you mean. They did excise something in there that didn't apply and shouldn't have been in there. That's all. Oh, somebody's asking, can she be charged for the second degree and the lesser included? I'm sort of paraphrasing your statement there. Oh, sorry, K Love, I'll get back to that in a second. Remind me. What was the question? I lost my train of thought. Oh, can she be charged with all of the things? Well, no, because in a way that is kind of like a double jeopardy, right? So if I hit you, you can't, I can't be charged with, I can't be convicted of the assault and an attempt, and right? It's the same act. So there's a principle in law, and it's called different things in different places, that the same act can't result in a whole, you can't, it's like charging the same crime over and over and over when when the charge actually encompasses that. I'm not sure if I'm explaining this well. The answer is no. They could have charged separate offenses. So they could have charged like an aggravated assault and that sort of thing. But the reason they didn't is because they didn't have the information, and because when they did get the information, the statute of limitations had run out and they couldn't. So that's why that is. Oh, somebody says Junior. Okay, why was Junior excised out? It's just language to keep the document consistent. Could you imagine someone like Owens getting a hold of a document where the last name is Torres, Torres, Torres all the way through, and then in one paragraph there's a mistake and somebody put Torres Jr.? Could you imagine an Owens with that? Oh my gosh, it's wrong, right? So they're just trying to be accurate or consistent through the document. So HRH mom says nothing has changed. Jury instructions are not going to sway the jurors' reactions. Linda, what I'm most looking forward to, in addition to see her face when she's convicted, is the judge's comments to her. Yeah. No Soup for You is saying, so they can decide manslaughter versus second degree. Yeah, they'll be given instructions on that decision, what the law requires. I think they have a solid second degree here because they showed the depraved heart. And there certainly was. Carolina is saying, were the text messages as bad as the videos? Yeah, well, they show she's as bad as she is. Ada, thank you. So KPM saying someone mentioned in court that Owens is preparing for his closing. I saw someone in chat saying, yeah, he's over at FedEx getting his stuff ready. Nikki's asking, when would sentencing take place if they get a verdict today? I know it would depend on the court schedule. I don't know. And they would do something akin to a pre-sentence report. Kimberly's asking me, how would you assess the threat that is Sarah Boone? I think that she will be damaging to people with whom she is in relationship with. I don't think that she's going to, plot multiple first degrees or anything like that, but she will, if she's allowed to be in a position again like she was with Mr. Torres, she will commit the same acts again, right? She will commit that same kind of abuse, and it may result in the demise of a human being, and she will be oblivious or not care about that. She has learned nothing. She has dug her heels in. She still is who she is. Nothing has changed. All the tumblers are there, so the only thing it would take would be the right situation. So if you leave her her in an apartment and let her have her alcohol and cause her chaos, that's one thing. But if the situation arises where there is a victim, yeah, she won't stop herself. And then there are other things too, such as driving under the influence. She has no problem with that. And if she hits somebody, she does. It's an accident. That would be her attitude. So the answer is yes, she poses a threat. There are different ways to pose a threat. And hers is not sorry, I'm trying to talk and I keep looking at the chat and then I lose my train of thought. Yeah, not all threats are the same and they don't all manifest in the same way, and not all protective measures that you can put in place are appropriate for everybody, right? So guys, I need to eat something. I am really tired and hungry, and I haven't been eating properly this week. And Watson needs some attention. So I'm going to sign off because I have less than half an hour. So I'm going to sign off now and see you in the afternoon stream. Thank you all so much for coming. Thank you for the way you treat each other. Do some self-care in the next little while, and I'll see you this afternoon.